This is the third part of the different kinds of obligations based on the Civil Code Article 1199 and 1233. Okay. So last time during the part 2, we tackled number 1 and number 2 in this list. So they are the pure and conditional obligations and an obligation with a period. Okay? And meron pa tayong 4. Okay? So alternative to an obligation with a penal clause. So bakit nga ba inuna natin yung number 1 and number 2 bukod sa number 1 and number 2 sila? Okay? Dahil yung mga naunang kinds of obligation na binanggit natin, pwede pa natin itong kumbaga mai-classify into parang kumbaga subcategory. Kumbaga kung ito yung major categories, numbers 1 to 6, meron pang subcategories, okay? Kumbaga pwede nating mag-group si number 1 and number 2 from the rest of the other kinds of obligation. So yung number 1 and number 2, these are the classification of obligations, or these are the kinds of obligations according to the peculiarity of the prestation. Okay? While number 3, this is a kind of obligation according to the number of prestation. So maya-maya makikita natin. Number 4, this refers to, however, hindi na siya tungkol sa prestation, kundi tungkol doon sa mga number of parties involved. Number 5, again, back to the prestation. So, number 5, it refers to the divisibility of the prestation. And lastly, number 6, it refers to the value of the prestation. So, maya-maya, i-explain natin kung bakit tinawag silang ganun. Okay? So, ayan. Let's start with alternative obligations. So, before going through with alternative obligations, i-classify muna natin yung mga different kinds of obligations according to the number of prestation. Usually, sa mga examples natin, isang prestation lang ang nababanggit. Okay? So, for example, sa isang obligation, ang obligation lang doon is to give a specific thing. For example, isang specific thing lang yon. So, nagpo-fall yun under a simple obligation. However, there are times na there may be 2 or more prestations. Okay? And furthermore, itong compound obligation na ito, which refers to 2 or more prestation, pwede pa siyang mahati into 2, which is first, the conjunctive obligation. So, in conjunctive obligation, there are 2 or more prestation, and the fulfillment, okay, the fulfillment of all the prestation will be the key to extinguish, okay, the obligation. However, in letter B, alternative obligation, it only gives you an option. Okay? Among those prestation, the fulfillment of only one of the prestation, for example, meron tayong 3 prestation, pag na-fulfill mo lang yung isa doon, may extinguish na yung obligation. Okay? So, that's the difference between a conjunctive obligation and an alternative obligation. Furthermore, dito sa alternative obligation, meron pa siyang variant, which is later on, pag-aaralan natin. This is called the facultative obligation. Pero, may pagkakaiba nga lang siya. So, maya-maya, i-discuss natin yan. Okay? So, our first article under the alternative obligation is Article 1199. Okay? Under Article 1199, a person alternatively bound by different prestations shall completely perform one of them. Okay? Ito yung sinasabi natin kanina na kapag alternative, isa lang, may extinguish na yung obligation once na na-perform nyo yun. Okay? The creditor cannot be compelled to receive part of one and part of the other undertaking. So, maya-maya explain natin yan. So, next article is 1200, Article 1200. The right of choice belongs to the debtor unless it has been expressly granted to the creditor. So, therefore, in alternative obligation, general rule, kapag walang sinabi sa problem, ang right of choice kay debtor. Okay? Magiging right of choice lang yun ng creditor kapag expressly binanggit sa problem. So, tatandaan nyo po yun. Okay? The debtor shall have no right to choose those prestations which are impossible, unlawful, or could have not been the object of the obligation. So, maya-maya may example tayo dyan. Okay? So, ayan. Okay, meron tayong first example. So, Gerald promises to deliver one of the following items to rent-free. Okay, so we have 3 prestations. Specific PC set number 1, specific PC set number 2, and specific PC set number 3. Okay. In alternative obligation, fulfilling or giving either of A, B, or C will extinguish this alternative obligation. From the word itself, makikita natin kasi to deliver one. Okay? One of the following items. Okay? Isingit ko lang dito kanina, yung nabasa natin sa Article 1199, yung the creditor cannot compel or cannot be compelled to receive part of one and part of other undertaking. So, explain natin yan using this, the example. Okay. So, for example, alam naman natin siguro na ang isang PC set, it's composed of different components such as the CPU, the monitor, the, what do you call this? The mouse and the keyboard, and other peripheral devices. Okay. So, yun. Assuming letters A, letter B, letter C, lahat ng mga components na yun, pare-parehas lang na meron sila, pero medyo siguro magkakaiba lang ng model or what, okay? Yun ang naging difference, okay? So, ang sinasabi doon sa second paragraph ng Article 1199 is, hindi pwedeng i-deliver mo yung, let's say, yung CPU ng PC set number 1, tapos yung other components, yung components ng PC set 2 para makumpleto yung isang ano. Okay? So, hindi po pwede yun. Hindi mo pwedeng i-compel. Pero pwede mong i-try. Okay? Kumbaga, pag pumayag si rent-free, walang problema, di ba? Basta alam niya na yung ibang component galing sa first set at yung ibang component galing sa second set. Okay? So, ganun yun. Pero, in terms of compelling, okay, rent-free or compelling the creditor, hindi po pwede. Pag sinabi natin compel, pilitin. Okay? So, that's the application of that second paragraph sa Article 1199. Okay? Okay, so ayan. Another example. So, medyo iniba natin siya. This time, specific phone, specific laptop, and specific tablet. So, ano ang i-illustrate natin this time? Ang i-illustrate natin this time is walang problema sa 1200 yung first paragraph. Doon sa second paragraph tayo. So dito the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. By referring to this example, siguro hindi pa yun mag-a-apply this time. Okay? Kasi kung mapapansin nyo, wala namang sigurong illegal sa isang specific phone, tablet, laptop, tablet, or whatsoever, di ba? Okay. So, moving on. Okay, moving on. Mamaya-maya ma-illustrate din natin yan. Okay, so Article 1201. The choice shall produce no effect except from the time it has been communicated. Okay. So, balik tayo dito. Itong alternative obligation na ito, by the way, mananatili siyang alternative obligation hanggat hindi pa na i-communicate yung choice. Okay? So, for example, ang general rule kasi, pag walang sinabi sa problem, yung debtor ang merong right of choice. So, in this case, si Gerald ang merong right of choice. Okay? Hanggat hindi pa na i-communicate ni Gerald kay rent-free kung ano yung pipiliin niyang i-deliver kay rent-free, okay, mananatiling alternative obligation pa rin to. Okay? Pero, once na na-communicate na ni Gerald kay rent-free, okay, yung kanyang choice, so for example, ang kanyang ibibigay na lang daw is yung specific laptop, from alternative obligation, yung obligation natin ay magiging isang simple obligation. Okay? So, tandaan, ano ulit ang simple obligation? Ang simple obligation ay meron lang isang prestation. So, tama, di ba? Okay? From alternative, meron tayong tatlo previously, pero nakapili na tayo. So, naging isa na lang. Okay? Yun na lang yung prestation natin, yung letter B na lang if ever ito yung napili. Okay? So, yun yung tatandaan nyo dito. Ito yung application ng Article 1201. From the time na na-communicate na yun, it ceases to be an alternative. Pero hindi pa siya extinguish. Hindi pa extinguish yung obligation natin. Nag-iba lang siya ng uri. Okay? From alternative, naging simple obligation na lang siya. Okay? So, ayan. Ayan, siguro dito na natin ma-illustrate yung kanina, yung second paragraph ng Article 1200. So dito, Gerald promises to deliver one of the following items to rent-free. Okay? Ang mayroong right of choice as a general rule ay si debtor. Okay? So, pagpipilian niya A, B, or C. So, specific from Pluto, letter B, specific laptop, specific tablet. Okay. So, physically impossible yung letter A. So, in this case, mag-a-apply yung second paragraph ng 1200, yung, okay, so balikan natin yung 1200. So, ayan. Debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Okay. So, pag binalikan natin yun, walang right si Gerald na piliin yung letter A. Okay. So, if ever pinili ni Gerald yung A, okay, hindi magte-take effect yung 1201 wherein, 'di ba, once na kinommunicate niya yung kanyang what do you call this, his choice, is yung alternative magiging simple na, hindi po. Okay, alternative pa rin siya, hindi niyo pwedeng piliin yung letter A. So pumili na lang siya ng iba na pwede. Okay, so hindi ito pwede. Okay, so ang pagpipilian niya na lang ay letters B and letter C kasi sila lang yung possible na, or parang kumbaga legally pwede niyang piliin or validly pwede niyang piliin. Okay? So, ayan. Kinross out pala natin. Okay? So, ayan. So, yung letters B and letter C, yan yung pwede niyang pagpilian. So, itong specific example na to ay mananatiling alternative obligation pa rin. Unless, syempre, may communicate na ni Gerald yung kanyang choice between letter B and letter C. Okay? Okay, so it remains to be alternative. Okay, so far guys, wala yung from Article 1199 to 1201, illustrate naman na natin, okay? So, let's move on to the next article. So, 1202. Under 1202, the debtor shall lose the right of choice when among the prestation whereby he is alternatively bound, only one is practicable. Okay, let's give an example. Okay. Ayan. Based nga sa Article 1200 ata yun, yung second paragraph, di ba sabi niya, hindi siya pwedeng pumili ng impossible, unlawful, and could not have been the object of the prestation. So, this example illustrates this. Okay, kung yun man daw ang nangyari, sabi na Article 1202, he loses the right of choice. Malamang. Kasi kapag isa na lang ang pagpipilian, so such as in this case, letter A hindi pwede, impossible, letter B unlawful, malamang, okay? Wala nang pagpipilian, yung letter C na lang talaga. Okay, so in this case, from alternative obligation, this will automatically revert to a simple obligation. Okay? Siguro okay lang naman. Siguro naintindihan nyo naman yun. Okay? Yung gustong ipahayag nung Article 1202. Okay? Very, naman siya, tawag dito, very straightforward, kumbaga. Okay? So, next. Okay. Okay. So, in this case, Gerald promises to deliver one of the following items to rent-free. So, hindi pwede lahat. Okay? So, ano mangyayari dito? Okay? Kung hindi pwede lahat. So, this is a void obligation, actually. Okay? Malamang, ang merong choice si debtor, si Gerald, pero wala naman siyang validly pwedeng piliin from among the prestation na nabanggit, di ba? Okay, so malamang this is a void obligation. Okay? Okay, so balik tayo. How about if yung kanina kasi impossible and illegal prestation, okay, so kapag impossible or illegal lahat as yung right of choice ay kay debtor, it will be a void obligation. Pero what if, okay, what if the reason is loss due to fortuitous event? Okay? Malamang yung mga prestation natin, itong mga to, valid naman sila, pero maya-maya, yun nga, ang mangyayari is what if nawala. Okay? Itong mga bagay na to. Okay, so assuming nawala yung specific phone. Okay? Ano mangyayari? Okay? This alternative obligation remains to be an alternative. Bakit? Kasi isa lang naman yung nawala. May pagpipilian pa. So, letters B and letter C. Meron pang magpagpipilian si debtor, which is si Gerald. Okay? So, alternative pa rin siya. So, hindi na siya magiging alternative once na nakapili na siya from letter B or letter C. At na-communicate niya na yun kay Renfree. Okay? What if dalawa naman ang nawala? Okay, via 4227 pa rin tayo Via 4227 pa rin. Okay, what if dalawa ang nawala? Isa na lang ano. Okay, so ganun din. Mag-a-apply yung sinabi ni Article 1202 na if only one is practicable, the debtor loses the right of choice. Malamang kasi wala na siyang pagpipilian. So letter C. Automatically, this obligation becomes a simple obligation. Okay? Letter C lang pwedeng niyang piliin. Specific tablet. Okay. So, 1203 naman tayo. Article 1203. If through the creditor's acts, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages. So, meron ba tayo example dito? Okay. So, ayan. Nawala. Okay. So, ayan. Ito yung example natin. What if through the creditors... hindi. Mali. May nakasulat pala na 4227. Okay. So, wag muna yun. Focus tayo dito sa 1203. If through the creditor's act, okay, so fault ng debtor kung bakit nawala yung mga prestation. Okay, so assuming, yun nga, nawala lahat, ibig sabihin, the debtor cannot make a choice kasi nawala lahat. Okay, according to the terms of the obligation, the latter may rescind the contract with damages. Okay, actually kahit na, let's say, iisa na lang, syempre, hindi na siya... Actually, may pagbibilihan pa siyang isa, di ba? Okay, pero pag nawala lahat, yun ang problema. Wala na siyang, kumbaga, hindi niya na ma-fulfill yung obligation. Hindi siya makakapili. Wala siya ma-communicate na choice niya. Okay? So, in this case, ang tanging, ang binibigay na remedy ni Article 1203 kay debtor ay to rescind the contract. Okay? With damages. So, magbabayad ng damages si creditor. Kasi, in the first place, fault ni creditor kung bakit, let's say, nawala or hindi makagawa ng choice si debtor. So, yun. 1203. Okay, next punta naman tayo. Balik pa rin tayo dun sa 4227. Kanina naputol kasi, yung first example natin, nawala lang yung isa. So, yung una, yung specific phone lang. So, therefore, meron pa tayong choice. Yung letter B at letter C, di ba? So, it remains to be an alternative obligation. Yung second example naman natin is nawala yung dalawa. Okay? Isa na lang ang natitira. So, in this case, this will be automatically converted into, what do you call this? A simple obligation. Pero what if lahat nawala? Okay? Kung lahat nawala, tandaan, this is due to 4227. And tandaan ulit, baka makalimutan nyo to, kasi maya-maya meron tayong example mamaya na hindi na general rule, which is pinasa kay creditor yung right of pinasa kay creditor yung right of choice. So iba rin ang rule doon. Ngayon, yung right of choice ni debtor muna, okay? So kapag nawala ito lahat via 4227, okay? Via 4227, okay, the obligation is simply extinguished. Okay? Parang ganun din lang sa rule kapag iisa lang yung prestation. 'Di ba kapag nawala pag binalikan niyo yung nature and effects of obligations, kung maalala niyo, 'di ba? Pag specific thing tapos nawala via 4227, the obligation is extinguished. Yun yung rule natin. Unless syempre may mga exemptions 'yon, pero yun nga, ang general rule is obligation is extinguished. Ganun din kahit na alternative pa 'yan. Okay, kapag nawala lahat via 4227, so extinguish yung obligation natin. Okay? So next, what if, okay, this time it's the debtor's fault. Okay, it's the debtor's fault naman na ngayon. So Gerald promises to deliver one of the following. So pare-pares pa rin yung example natin. So, what if nawala yung letter A, specific phone? The answer is, this obligation remains to be alternative. Bakit? Kasi meron pa naman dalawang choices. Specific laptop and the specific tablet. Okay? So, wala tayong problema. Okay? So, tatanungin nyo ako, sir, yung letter A, nawala via debtor's fault? It doesn't matter actually kasi choice naman ni debtor eh. In the first place, pwede niyang hindi piliin yan, di ba? Okay, so, ayan. This case remains to be alternative. Okay, kasi may dalawa pa namang pagpipilian. Okay? Next example, ganun pa rin. Ganun pa rin, hindi nagbago, pero this time, dalawa na ang nawala, specific phone and a specific laptop. So, as a rule, ganun pa rin. Okay? This obligation becomes automatically a simple obligation. Bakit? Iisa na lang ang pwedeng piliin. Validly pwedeng piliin ni debtor. Okay? Which is the specific tablet. Hindi niya naman pwedeng piliin yung A or B kasi tawag dito, nawala nga eh. So, hindi niya pwedeng piliin. Okay? At ang isa pa, tatanungin niyo ako, sir, debtor's fault yung naging reason kung bakit nawala yung A and B. Inuulit ko, nandito pa lang tayo sa right of choice ni debtor. Ibig sabihin, in the first place, pwede niya naman talagang hindi piliin yan, yung letters A and letter B. Diba? So, it doesn't matter. Okay? Okay. Now, let's move on to Article 1204. Anong sinasabi nito? The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the thing last, or of the last thing which disappeared, or that of the service which last become impossible. Damages other than the value of the thing or service may also be awarded. Okay, so kanina, ang mga examples natin under loss via debtor's fault, and syempre nandito pa rin tayo sa first rule, which is the general rule, yung choice of the debtor. Yun nga, nawala yung specific phone, nawala yung specific laptop, pero wala pa ring problema, di ba? Wala pa rin problema. Hindi pa rin nagbabayad ng damages si debtor kasi yun nga, meron pa ring naiiwan. Pero what if nawala lahat? Okay? So, pag nawala lahat, the debtor is obliged to pay the value of the last thing lost plus damages. Okay? So, kapag ang huling nawala ay yung, tandaan nyo, based dun sa nauna, yung previous example natin, di ba? Kapag nawala yung una, yung specific phone, and nawala yung specific laptop, anong sabi natin kanina? This alternative obligation automatically, what? Automatically reverts to a simple obligation. Meaning, okay, isa na lang yung prestation natin. Tama? Okay. Kapag isa na lang yung prestation natin, balikan natin yung, what do you call this? Our nature and obligations, chapter 2, di ba? Kapag nawala ang isang specific thing via debtor's fault, ano ang magiging parang kumbaga consequence? Magbabayad siya ng damages. So, ayun nga. Yun ang nangyari. Okay? So, assuming yun nga, nawala yung specific phone, nawala yung specific laptop, automatically, naging simple obligation na lang siya, which is to give a specific tablet. Diba? Okay, so from that time, pag nawala yun via debtor's fault, yun nga, magbabayad na siya ng damages. Okay? Value of the lasting loss plus damages. Okay? Value of the specific tablet plus damages. Okay? Pero huwag nyo kakalimutan ulit, na nasa general rule pa rin tayo, which is the choice of the debtor, and this is the reason for the loss is via debtor's fault. Okay? So next, punta na naman tayo sa Article 1205. Ano ang sinasabi ng Article 1205? When the choice has been expressly given. Okay, so this time, pupunta na tayo sa second, yung, kumbaga second rule, which is hindi na siya choice of debtor, punta na tayo sa choice of the creditor. Okay, when the choice has been expressly given to the creditor, the obligation shall cease to be alternative when the selection has been communicated to the debtor. Okay, so baliktad lang. Malamang-lamang kapag ang merong right of choice ay si debtor, ang magko-communicate ay from debtor to creditor. Iko-communicate ni debtor kay creditor. Pero kung si creditor naman ang merong right of choice, malamang, okay, manggagaling kay creditor yung communication papunta kay debtor, okay? So ganun lang din yung sinasabi ng first paragraph dito sa 1205. Kung tama ako ng pagkakaalala, nasa yun, yung parang kumbaga Article 1201 ata yun, yung para sa kapag ang mayroong right of choice ay si debtor. Okay? So, basahin natin yung mga sumusunod. Until then, the responsibility of the debtor shall be governed by the following rules. Okay? So, number 1, if one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor choose from among the remainder, or that which remains if only one subsists. Okay? So, very simple lang. Number 2, if the loss of one of the thing occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which through the fault of the former has disappeared with the right of damages. Okay, so may explain natin yan. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any of them, also with indemnity for damages. Okay? Ganun din, connected tong 2 and 3. So, maya example natin yan. The same rules shall be applied to obligations to do or not to do in case one, some, or all of the prestations should become impossible. So, kung mapapansin nyo guys, ang mga example natin dito ay obligation to give. Okay? Pero sabi nga dito, mag-apply din siya sa mga obligations to do and not to do. Okay? So, ayan. Punta na tayo dito sa ganun pa rin yung example natin, pero yun nga, this time, digdan yung mabuti to, choice of the creditor. Okay? So, ayan. Rules. Okay? Gerald promises to deliver one of the following items to rent-free. Okay? So, ganun pa rin. Okay, ano yan? Okay, naulit lang yung kanina. Okay, ano yan? Okay, wala tayong problema doon sa ano. Okay. Yung sa under impossibility or illegality, whether it is the choice of the creditor or the choice of the debtor, walang pagkakaiba. Kung mapapansin nyo kasi dito yung example natin, okay, so ayan, ito yung example natin kanina sa choice of the debtor. Nawala yung, hindi pwedeng isa kasi impossible, so remains to be alternative pero limited lang yung option between letter B and letter C. So si creditor pwede lang pumili between letter B and letter C. Ganun din sa ito. Okay? This time pero, isa na lang ang matitirang choice na pwede. So, in this case, walang choice si creditor, kundi piliin yung letter C. In this case, it automatically becomes a simple obligation. Okay? So, what if wala? So, it is a void obligation. Kasi in the first place, wala naman tayong prestation. Diba? Wala tayong valid prestation. Okay. So, ayan. Punta na tayo sa yung mga rules. So, ulit, okay? So, Gerald promises to deliver one of the following items to rent-free. So, this time, ang pagkakaiba from our previous example is that the choice now belongs to the creditor, okay? So, may tatlo pa rin tayong choices, specific phone, specific laptop, specific tablet. So, what if nawala yung first item natin via 4227? Actually, walang pagkakaiba ito kapag ito ay choice ni debtor. Okay? Si creditor, meron siyang choice doon sa maiiwan, letter B and letter C din. Pero, in this case, this remains to be alternative kasi meron pang mga option. Pero what if nawala yung dalawa via 4227? Again, same with the rule na nabanggit natin kapag choice ito ni debtor, di ba? Kasi this time, choice ni creditor. Same still with the rule ng choice ni debtor. This automatically becomes a simple obligation. Simple lang kasi wala nang pwedeng maging choice. At isa pa, fortuitous event kasi yung naging reason kung bakit nawala yung specific phone, specific laptop. Walang may gusto. Okay? So next, what if nawala lahat? Again, the obligation is extinguished kasi fortuitous event ang naging reason. Okay. So kung mapapansin nyo, kapag ang pagkawala ng bagay ay via fortuitous event, it doesn't matter if it is the choice of the creditor or if it is the choice of the debtor. Okay? The rule is the same kapag ang reason of loss is via fortuitous event. Okay? So dito na tayo magkakaroon ng pagkakaiba. What if the loss is due to the debtor's fault? Okay. So, what if letter A is lost, the specific phone? The choice of the creditor, okay, will remain to be ilan? Ilan na magiging choices natin? Dalawa na lang ba? No. Okay? This remains to be alternative. However, the choice remains, the same. Tatlo pa rin. Okay? Pwede niya pa rin piliin yung specific phone. Pero, bakit? Nawala. Di ba? Nawala na ito. Okay. Actually, syempre hindi niya naman madedemand yung specific phone talaga. Okay, yung mismong phone hindi yun mismo ang ide-demand niya. Kapag ito ang pinili niya, yung specific phone, ang ide-demand niya is hindi yung mismong specific phone, kundi yung value ng specific phone plus damages. Pero kapag ang pinili niya ay yung mga hindi nawala, for example, letter B or letter C, hindi siya pwedeng maningil ng damages kasi hindi naman nawala. Okay? So, ganun. Ang pagkakaiba, di ba, kapag choice ni debtor, okay, kung ano na lang yung natira, yun na lang ang choice niya. Pero, iba kapag choice ni creditor. Pwede niya pa rin piliin yung nawala. Kasi, yun nga, ang reason ng pagkawala ay via debtor's fault. So, kapag pinili niyo yung nawala, in addition to the value of the thing loss, pwede pa siyang makasingil ng damages. Okay? So, yun yung pagkakaiba this time. Okay, so ayan, nilagay natin. Okay? Value of phone plus damages. Okay, what if, yun nga, nawala yung dalawa via debtor's fault and yun nga, naiwan na lang si specific tablet. Kung maalala nyo, ang rule dito, kapag choice ni debtor, automatically magiging simple na lang siya kasi isa na lang yung, tawag dito, isa na lang yung pagpipilian. Pero in this case, okay, tatlo pa rin yung pagpipilian ni creditor. Bakit? Yun nga, kapag siya ang pumipili, pwede niya pa rin piliin yung mga nawala. Okay? Pero, syempre, hindi niya i-demand yung mismong specific thing na yon, kundi yung value lang. Okay? Value of the phone plus damages or value of the laptop plus damages. Pero if the creditor happens to choose the specific tablet, hindi pwedeng maningil ng damages kasi hindi naman nawala yung specific tablet. Okay? So, ganun lang po yun. Okay. So, ayan. What if nawala lahat? Okay. Ganun pa rin. Meron pa rin tatlong choices. So, ayan. Lahat na may damages this time kasi lahat na nawala. Okay? So, pili na lang siya. Okay? So, ayan. Sa ating link na nakalagay sa description, may mga, okay, so meron tayong course website, so tingnan nyo na lang. Meron tayong mga different questions dito para matest nyo kung naintindihan nyo ba ang ating alternative obligations, okay? So, punta naman na tayo sa facultative obligation. Facultative obligation is a variant of an alternative obligation. So, Article 1206. When only one prestation has been agreed upon but the obligor may render another in substitution, the obligation is called facultative. Okay? May explain natin yan. Second paragraph, the loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Okay, so as an example, okay, facultative obligations, obligation with only one prestation. Unlike the alternative, yung alternative kasi merong 2 or more prestation and performing one of those prestation will extinguish the obligation. Pero kapag sinabi nating facultative obligation, iisa lang po ang prestation kasi at one moment in time, isa lang ang effective prestation. Although, siguro sa isang problem, maya-maya, i-illustrate natin, may dalawa kayong possible prestation na pwedeng mag-apply dun sa obligation. Pero, at a moment in time, isa lang ang active prestation na tinatawag doon. Okay? So, ayan. Tignan natin. Okay? Gerald promises to deliver a specific laptop to rent-free and also stipulated that he may deliver a specific tablet as a substitute. Okay. So, in this case, i-analyze natin kung bakit ito naging facultative obligation. Although meron tayong dalawang prestation na nakikita dito, okay, to give a specific laptop, to give a specific tablet. At a moment in time, isa lang ang active prestation. Okay? Unlike kasi sa alternative, lahat yun active. Okay? Kasi anytime, pwede doon sa tatlong yun, piliin niya, di ba? Piliin niya kung ano yung i-deliver niya. Okay? So, ayun. Pero in the case of facultative, at a certain time, isa lang ang active prestation. So, hanggat wala pang substitution, ang ating active prestation dito ay syempre, yung specific laptop, yung unang nasabi. Pero once na nagkaroon ng substitution, so yun yung trigger, yung substitution, okay, yung specific laptop, hindi na po yun yung magiging prestation natin. Mapapalitan na siya ng specific tablet, okay? So, ang active prestation natin ay yung specific tablet in that case kapag nagkaroon ng substitution. Okay. So, number 1, tignan daw natin. Identify if substitution was already made. Okay. So, ganito. In answering facultative obligation problems, you must always, okay, determine if the problem indicates that there has been a substitution. Kasi yun yung trigger eh. Okay, yun yung parang event na tinitignan natin. Okay, para makita kung ano ba yung currently active prestation at the moment. Okay, kapag walang sinabi sa problem na meron ng substitution, okay, ibig sabihin wala pang substitution. Pero kapag may sinabing nagkaroon ng substitution o meron ng substitution, ganun lang naman yung kasimple. Babanggitin yan ng problem kung meron ng substitution. Okay, so tayo na lang ang bahala kung ano bang alam natin kung kumbaga nagkaroon ng substitution, so what now? Parang gano'n, okay? So, ganun nga, identify the prestation and the substitute. Okay? So, inuulit ko, kapag wala pang substitution, ang active prestation natin is yung principal object. Yung una na nabanggit dito, di ba? Gerald promises to deliver. Tapos substitute lang si specific tablet kasi. So, hindi siya yung principal object. Ang principal object dito ay yung specific laptop. Okay, substitute yung specific tablet. Okay? So, inulit ko, kapag before substitution, kapag wala pang nangyayaring substitution, ang prestation in effect ay si principal object, which is in this case, specific laptop. Pero once na nangyari na ang substitution, okay, ang prestation in effect ay yung specific tablet na, which is the substitute. Okay? So, why is it important na malaman kung ano ba yung currently active prestation? Okay, so if the loss or deterioration of the prestation happened before, so anong sinasabi dito? Debtor is liable if he is the cause of the loss. Okay, so anong sinasabi dito? Okay, so basahin natin. If loss or deterioration of the prestation happened before substitution, debtor is liable if he is the cause of loss or okay. So, pag sinabi natin kasing prestation dito, we are referring to the hindi ko nailagay. Actually, we are referring to the principal prestation. Okay? Principal. Okay, tatandaan nyo na lang. We are referring, when we say prestation dito, we are referring to the principal prestation, not the substitute. Okay? So, number 1, if the loss or deterioration of the principal prestation happen before substitution. So, ibig sabihin, currently, pag hindi pa nagkakaroon ng substitution or before substitution, ang active prestation natin ay yung principal prestation. Tama? Di ba? Debtor is liable if he is the cause of the loss or deterioration. Ibig sabihin, kapag nawala yung principal prestation natin before substitution, at ang naging cause, let's say, ay yung fault ni debtor, magiging liable siya for damages. Pero kung ang naging cause naman ay, let's say, what do you call this? Fortuitous event, walang problema kasi yun nga, di ba? Pag fortuitous event, general rule, walang liability. Okay? Walang liable in case of fortuitous event. So, number 2, if the loss or deterioration of the prestation happen after substitution, the debtor is liable even the debtor is liable. Okay, even if he is the cause. Okay. So mali. Okay. The debtor is not okay. The debtor is not liable even if he is the cause of the loss or deterioration. Kasi sa madaling salita, ganito. Kapag nagkaroon na ng substitution, yung principal prestation natin dito, hindi na ito yung active prestation natin. Kasi nagkaroon na ng substitution, di ba? Sabi ko, kapag nagkaroon na ng substitution, ano na ang active prestation natin? Ang active prestation na natin ay yung substitute. So, kung ano man ang mangyari dun sa dating principal prestation natin, wala na tayong paki doon. Okay? Kahit pa ang naging cause ng loss ay, let's say, yung fault ni debtor, hindi na siya magiging liable doon. Okay? Ang meron na lang effect sa obligation is kapag kung ano man ang nangyari dun sa substitute. Kasi nandito na tayo sa point in time wherein nagkaroon na ng substitution. Okay? So next, ito naman, okay, we are talking about the substitute. So if the loss or deterioration of the substitute happened before substitution, the debtor is not liable even if he is the cause. Okay, so yan dapat yung nakasulat kanina dito sa number 2 dito, di ba? So number 2 dito, yung dapat nakasulat. Okay, so ayan. Wala tayong pake sa substitute kapag wala pang substitution. Okay, substitute lang siya. So ano man ang mangyayari sa kanya, wala pang effect, okay, sa obligation. Okay, hanggat wala pang substitution. Pero once na, let's say number 2, nangyari na yung substitution, siya na ang magiging bagong principal prestation. Okay? So in this case, ano man ang mangyari dun sa substitute dati, meron ng effect dun sa ating obligation. So if ever nawala ito via debtor's fault, so yun, magbabayad si debtor ng damages. Okay? Okay, so ayan. Mukhang kailangan nating magbigay dito ng example. Okay? Okay, so balik tayo dito. Okay. So ito ay isang facultative obligation. Kapag si Gerald, okay, so in this case, ang ating principal prestation is the specific laptop at ang substitute ay yung specific tablet. Okay, assuming hindi pa nagkakaroon ng substitution. Okay, so dapat babanggitin niya sa problem. Okay. Kapag nawala yung specific tablet via Gerald's fault, ano ang effect nun sa ating obligation? So, itest natin ang sarili nyo. Okay, anong effect nun sa obligation? The answer is, no effect. Kasi wala pang substitution. Wala tayong pake ano man ang mangyayari dun sa substitute. Okay, kasi hindi pa siya part ng obligation. Tama, di ba? Okay. What if may nangyari doon sa specific laptop? Siyempre, merong effect yun sa obligation. So, depende na lang kung sino ang naging reason kung bakit nawala yung laptop or nag-deteriorate yung laptop or whatsoever, di ba? So, kapag nawala yung laptop via 427, extinguish yung obligation natin. So, kasi no one shall be liable for 427. So, in this case, yun nga. Pero paano kung nawala siya via Gerald's fault? So, in that case, magbabayad si Gerald ng damages. Okay? So, what if naman, okay, this time, what if nagkaroon na ng substitution? Meaning, okay, balikan muna natin yun, sandali. Kasi may naalala ako bigla na question, okay, na kadalasan sinasagot ng mga estudyante, okay. So, kapag nawala yung laptop, okay, via 4227, meron kasi usually sa mga problems wherein merong choice doon na kapag nawala daw si specific laptop via 4227, meron pa naman daw si tablet, si substitute na pwedeng i-substitute at yun na lang ang magiging obligation. Actually, mali po yung na yun kasi yun nga, kapag wala pang naging substitution, walang effect, okay? Hindi pwedeng mangialam yung substitute sa obligation natin. So, kapag nawala yung specific laptop, automatically extinguish yung obligation. Okay? So, kung sakaling nagkaroon ng usapan si Gerald at Renfrey na yung specific tablet na nga lang. Okay? So, mukhang ibang topic na yon. Okay? So, siguro punta na tayo dun sa sa part na ng novation yon sa chapter 4 on this topic, obligations. Okay? Pero, under facultative obligation, ang rule natin doon kapag nawala yung specific laptop via 4227 at wala pang substitution na nangyayari, it will cause the extinguishment of the obligation. Okay? So, next, punta tayo ulit. What if naman nagkaroon na ng substitution? Wala na tayong pakialam ano man ang mangyayari dun sa specific laptop. Okay? So, si specific tablet na ang merong effect sa substitution, sa obligation. Okay? So, kung nawala yung specific tablet, syempre, depende ulit kung via 427 or via debtor's fault. So, kapag 427 extinguish, kapag via debtor's fault, that will be indemnity for damages. Okay? So, na tayo? Move on na tayo sa facultative. Okay, so before we move on to the next topic, tingnan muna natin yung pagkakaiba, yung major differences between the alternative and facultative obligation. So, alternative, meron tayong 2 or more prestation. While in facultative, there is only one prestation. Okay? Next difference is the debtor or the creditor may have the right of choice. However, in facultative, only the debtor has the right of substitution. Never na pwedeng ibigay yan kay creditor. Okay? So, next. The illegality or impossibility of one prestation does not invalidate the whole obligation as long as there are remaining valid prestation. Okay? However, in facultative, the illegality or impossibility of the prestation invalidates the whole obligation even if the substitute is valid. Okay? So, yan. Kasi, yun nga, initially, kung invalid yung principal object natin, ibig sabihin, wala tayong obligation in the first place kasi 'di ba isa sa mga requisite ng obligation or essential element ng isang obligation is dapat merong valid prestation, 'di ba? Okay, which is kapag illegal or impossible siya as if walang prestation. Okay? So even if the substitute is valid, it doesn't matter kasi at that moment wala pa namang effect yung substitute dun sa ating obligation. Okay? So let's move on to the next, okay, type of obligations, which are joint and solidary obligations. Okay? So under this joint and solidary obligations, so ayan. Pero yun nga, mag-cycle tayo from to all the different articles para wala tayong ma-miss out. Okay, so starting from, tama ba? Ano ba ang huling article dito? Okay, so tama, 1206, tapos punta tayo sa 1207. Yun yung first article under the joint and solidary obligations. So anong sinasabi dito? 1207. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestation. This is a solidary liability on there is a solidary liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. So maya explain natin yan. Okay. So sabi ko nga kanina kapag joint and solidary, this time we are not this is not about the prestation. This time it's about the active subjects and the passive subjects. Okay, when we talk about joint and solidary obligations, there are multiplicity or there are many. Okay, there are many yung mga tao dito, mga active subject or passive subject or simply the creditors and debtors. There are many creditors or there are many debtors or both, di ba? Okay, or both. Okay. So, ayan. Pero kung ganun nga, anong magiging rule? What if, for example, ABC may utang kay XYZ na 10,000, no? So, anong implication nun dun sa obligation? So, meron. So, may explain natin. Okay? So, ano ba yung nakasulat dito? Refers to the juridical tie, okay, of the debtors or creditors. So tama. Concurrence of multiple creditors or debtors or both in one and the same obligation. So, tama. Okay? So, one and the same obligation. So, yung maya-maya yung mga magiging examples natin, kung mapapansin nyo, iisa lang yung prestation. Okay? Pero there are multiple creditor or multiple debtors or both. Okay? So paano yun? Paano ang hatian doon? So, tingnan natin. Okay, Article 1208. If from the law or the nature or the wording of the obligation to which the preceding article, so we are referring to yung article kanina na binanggit natin yung 1207, refers the contrary does not appear, the credit or debt shall be presumed to be divided into as many shares as there are creditors or debtors. The credits or debts being considered distinct from one another, subject to the rules of the court governing the multiplicity of suits. Okay, so actually yung Article 1208 dito natin napulot yung general rule wherein kapag hindi binanggit sa problem whether it is a joint or solidary obligation or whether multiple creditors or multiple debtors are joint creditors or solidary creditors or joint debtors or solidary debtors. Sa Article 1208, sabi niya, the credit or debt, okay, shall be presumed to be divided into as many shares as there are creditors, implying na between joint and solidary, if walang nabanggit or hindi malinaw, okay, we will favor joint. Okay, so joint siya. Okay, kung hindi malinaw. So, ganun din sa mga pagsagot ng mga problems. Kapag walang binanggit sa problem, whether the creditors or the debtors are joint or solidary, joint siya. Okay? So, magiging solidary lang siya once na nabanggit or expressly binanggit sa problem na sila ay solidary debtor or solidary creditor. Okay, so ayan. So, ano nga ba yung solidary joint? So, yan. Ito yung ano muna. Okay. The concurrence, yun yung ano, kunwari, pwedeng maraming creditor sa isang utang lang. So, lahat sila creditor, pero with regards to only one debt. Okay? So, for example, utang na 1 million. Okay? So, meron tayong, let's say, 3 creditors. So, lahat sila creditors with regards to the 1 million. So, merong concurrence of multiple creditors in one prestation, which is the obligation to give 1 million, di ba? Okay. So, anong pagkakaiba ng solidary at joint? Unahin muna natin yung solidary. Pag sinabing solidary, each one of them or each one of the creditors has a right to demand the entire compliance with the prestation, while each one of the debtors has an obligation to render entire compliance with the prestation. Okay? So, kanina, yung example natin, 1 million na utang. So, sabi natin kung what if meron tatlong, okay? What if merong tatlong creditors? Okay? So, creditor A, B, and C. Okay? Lahat sila merong silang right. Okay? Any one of them has the right to collect, okay, the entire obligation, which is the entire 1 million. Okay? Ganon din sa debtor. Pag debtor naman, baliktad. Hindi sila yung merong right to collect. This time, they have the obligation to pay. Okay? So, let's say we have debtors XYZ. Okay? Debtors XYZ are solidary debtors with regards to a 1 million peso debt. So, any one of them is obliged to pay the entire 1 million peso na obligation. Okay? However, when we say joint, okay, we only refer, okay, a creditor or a debtor has the right or right slash the obligation to collect slash pay, okay, slash pay only his share. Okay? So, for example, wag yung 1 million kasi mahirap i-divide sa tatlo. So, for example, ang utang ay 900,000. Meron tayong tatlong creditors. Assuming they are joint creditors, okay? Creditors A, B, and C are joint creditors with regards to a 900,000 peso debt. Each one of them has only the right to demand their share. So, kapag walang binanggit, every time na may mga problem na ganito, kapag walang binanggit kung paano ang hatihan, ang assumption ay according to initial, syempre joke lang, okay? So, partnership yun, initial, yung capital balances. Okay, pero, so this time, okay, equally, okay? Yun yung general rule natin kapag let's say 900,000 tapos tatlong creditor, so wala na nang binanggit kung ilan yung share ng bawat isa. So ang assumption ay equal, okay? So therefore, si creditor A, meron lang siyang right to demand his share, which is 300,000, okay? Pero from whom? Okay? Problema na naman, di ba? What if there are multiple debtors na pwedeng singilan? So maya may example tayo diyan, syempre, okay? So ito yung mga other terms, baka kasi biglang mabanggit or iba yung gamiting terms sa mga quizzes nyo or sa mga exams nyo. So, under joint o jointly liable, conjoint, mancomunada, simple, prorata, proportionate. Okay, so solidary, joint, and severally. So, maraming nagkakamali dito. Kapag nabanggit to, joint and severally, akala nila joint. Okay, pero actually this is solidary. Okay, so insolido, mancomunada, solidaria, juntos, bla 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 bla. Okay, so kayo nang bahala dyan, memorize nyo na lang yan. Okay, so next. Punta na tayo sa example. Okay, so A, B, and C are bound to pay X, Y, and Z 9,000 pesos. Okay, so isa lang yung prestation natin, which is to give 9,000. And there are multiple creditors and debtors. So, by analyzing the problem, the debtors are A, B, and C, while the creditors are X, Y, and Z. Okay, so problema to. Paano ang singilan dito? At paano ang bayaran dito? Okay. Balikan natin yung rule kanina, which is, ano ba yung rule kanina na sinabi ko? Kapag hindi malinaw whether this, what do you call this? These creditors or debtors are jointly or solidarily liable, ano ang magiging rule? According to, anong article na yun? Nakalimutan ko na. So, 1202 ata. Okay, so, 1207 ata or, okay, never mind. Okay, basta merong yung rule na banggit natin kanina. Ano yun? So, they are presumed to be joint. Tama? Joint. Joint. Kasi walang sinabi. ABC are bound. Sinabi lang na debtor sila, pero hindi sinabi whether they are joint or solidary. Okay, ganun din kay creditor, XYZ. So, ang assumption, joint. Okay? Ang tanong, okay, so the first question will be, ganito. How much is the share of A, B, and C in the debt? Okay, so sino si A, B, and C? Sila yung mga debtors. So, sabi natin, kapag hindi rin malinaw kung paano ang hatian, ang assumption ay hati-hati, equally. So, they have 3,000 pesos each na share. Tama? Okay, so bakit importante ito? Maya-maya. Importante ito. Bakit? So, maya-maya makikita nyo. Okay, this time, ano naman ang share ni XYZ in the debt? So, ganun din. Diba? Hindi malinaw whether kung ano ang hatian. So, therefore, equally ulit. So, 3,000 each. Okay, so this time, pagbanggain natin. Okay. How much is B liable to pay? Okay, magkano ang babayaran ni B? Or magkano yung amount which is liable siya na bayaran? Di ba? So, obviously 3,000. Kasi pag joint, inuulit natin, kung binalikan natin yung dalawang box na nakaganito, yung solidary dito, tas joint dito, okay. Kapag joint, sabi niya, okay, obliged lang isang debtor na magbayad ng kanyang share up to the extent ng kanyang share lang. Hindi siya liable bayaran yung share ng iba. Okay, unlike sa solidary. Kapag solidary kasi, liable ka pa rin. Okay? Kailangan mong bayaran. Kung sakali ikaw yung siningil, kailangan mong bayaran yung share ng iba. Okay? Pero maya-maya, ano natin. So, pero in this case, joint naman. So, hanggang sa share mo lang. So, napag-usapan natin is ang share lang nila is hanggang 3,000. So, syempre, ang liable lang si B, specifically si B, na bayaran ay yung kanyang share, which is 3,000. Tama. Okay? So, how much can Z collect this time? Okay. Ganun din, binanggit ulit natin kanina na kapag joint, ang pwede lang makolect ng isang creditor ay up to the extent ng kanyang share. So, ang kanyang share ay up to 3,000. So, hanggang 3,000 lang pwedeng makolect ni Z. Okay? So, tatandaan nyo po yan. Okay? So, ito na yung magandang part. How much is B liable to pay X? So, this time, okay, in-specify natin in one question. Isang debtor, isang creditor. Okay? This time, anong sagot natin? Ano kayang sagot natin sa tingin nyo? Okay. So, ang sagot natin is 1,000. How much is B liable to pay X? Okay. I-specify natin eh. Kung maalala nyo, kapag ang tanong lang ay how much is B liable to pay? Walang specific creditor. Ang sagot ay 3,000 kasi yun yung kanyang share, di ba? Yun yung kanyang up to the extent ng kanyang share. Pero, paano madidistribute yung 3,000 na yon na ibabayad niya? Simple lang. Madidistribute dun sa tatlo, di ba? Yung, di ba, all in all, meron siyang 3K. Okay? So, 1K para kay, ano ba yan? 1K para kay X, another 1K para kay Y, and another 1K para kay Z. So, all in all, meron tayong 3K. Okay? So, pag ang tanong, how much is B liable to pay X? O, ayan, 1,000. Okay? Ganon din, magiging sagot kapag ang tanong dito is how much is B liable to pay Y? So, 1K din. Okay? So, next question. How much can Z collect from A? Nabaliktad lang yung question actually. Kanina, liable to pay. This time, collect. Okay? Kung maalala natin, kapag ang tanong lang is how much can Z collect? Okay? The answer is up to the extent ng kanyang share, which is 3,000. Pero, this time ulit, nag-specify tayo ng isang debtor. So, ganun din. Si Z, pwede siyang makakolekta from, okay? Kasi talo yung debtors natin from A, B, and C ng 1,000 each. Okay? Totaling 3,000. Okay? So, tama. Okay. So, ayan. So, meaning, ang sagot ay 1,000. Okay? Next. Okay. Okay. So, na-spoil tuloy. How many distinct debts are there? Okay? So, there are 9 distinct debts. So, ano yung mga yon? Ito yung mga yon. Yung obligation ni A kay X, 1,000. A kay Y, A kay Z. Okay? And so on, hanggang 9. Totaling up to 9,000. Yung buong kumbaga, parang pinag-connect. Matching type. Okay, A, B, C. Pero lahat dapat ma-match. Diba? X, Y, Z. So, pag mga ganitong question, simple lang, i-multiply mo lang, 3 times 3 equals 9, ganun lang lagi yun. Okay, so ayan. Okay, nakakonnect na sila lahat. Okay, so kasi joint sila pareho. What if, ang magiging problema ulit dito is, what if, hindi sila joint pareho? Yung debtor, joint, pero yung creditor, solidary. Okay, so yan, tignan natin. Okay, so this time, hindi na sila joint lahat. Kasi, this time, yung creditor, solidary. Specifically, binanggit solidary. Okay, so ayan. Okay, so A, B, C are bound to pay solidary creditors X, Y, Z. Okay, si A, B, C ay joint pa rin kasi wala namang binanggit. Okay, so first question. Okay, wala. First question. Okay, analysis muna. Debtors A, B, C. So, joint or solidary. So, ayan. Okay. So, first question tayo. How much is the share of A, B, and C in the debt? Okay. Obviously, they have 3,000 each, di ba? Okay. Parang ganun pa rin sa last time kasi hindi naman nabago. Joint pa rin sila ngayon. How much is the share of X, Y, and Z in the debt? Okay. 3,000 pa rin. So, hindi na bago. Kahit na solidary sila. Actually, tama pa rin yung sagot natin dito. Tama na 3,000 each pa rin yung share nila. Pero, hindi yun tungkol sa share eh. Okay? Yung solidary, yung pagiging solidary creditor, hindi yun tungkol sa yung share mo. Okay? Ganun pa rin yung share mo. Pero, yun nga, di ba? Ang pwede mong singilin, ang maiiba is yung pwede mong singilin. Which is, tingnan natin. Di ba? Sa next question. How much is B liable to pay? So, total hindi naman na bago, joint pa rin. Tama, 3,000. Pero kapag nagbanggit na tayo kung magkano yung babayaran niya specifically sa isang depende. Tingnan natin. How much can Z collect? Okay, so medyo, ngayon? Sabi natin, inuulit ko, kapag solidary, balikan natin yung joint. Pag joint, up to the share lang ang pwede mong collect. So, 3,000. Pag joint, yun ang isasagot natin, 3,000. Pero this time, hindi siya joint. Solidary siya. Okay, so therefore, sabi natin, under solidary, okay, ang pwede nating makolek or bayaran, kapag in case of debtor, is the whole obligation. Okay, so 9,000. Okay? So ayan. Mamaya explain natin kung bakit 9,000. Okay. So how much is B liable to pay X? So naging specific na tayo. Okay, how much is B liable to pay X? Ngayon, nagbanggit tayo ng specific person. Pero actually, it doesn't matter. Actually, kahit na ang nabanggit ay si Y or si Z, dahil ang babayaran niya pa rin ay ibabayad niya na lahat ng kanyang share, which is the 3,000. Okay? Kasi, Whether si X, whether si Y, or whether si Z, meron sila lahat. Okay? Lahat sila, dahil sa pagiging solidary creditor, lahat sila, okay, pwedeng maningil. Okay? Ng kahit anong utang. Kahit utang ni A, kahit na utang ni B, kahit na utang ni C. Okay? So, lahat sila pwedeng maningil. So, dito naman, how much can Z collect from A? Okay? So, si Z, okay, sabi natin, si Z, ang pwede niyang makolect overall ay 9,000. Okay? Pero, this time, nabanggit tayo ng isang specific debtor. Okay? Ang pwede niyang singilin specifically from A ay 3,000 pa rin. So, bakit? Okay? Bakit hindi niya pwede singilin yung 9,000? Malamang, si A kasi ay isang joint debtor. At ang pwede niya lang bayaran ay up to the extent ng kanyang share. Okay ba? Pero, okay, hindi ibig sabihin na kinokontradict natin yung sinabi natin kanina, which is, magkano ba ang pwedeng singilin ni Z? Lahat. 9,000 pa rin. Kasi, later on, pwede pa rin namang maningil si Z from B. Makokolekta niya yung 3,000 ni B. At ganun din kay C. Okay, so overall, makakasingil siya in total ng 9,000. Okay? So, kapag nasingil niya lahat yung 9,000, anong gagawin niya? Itatakbo niya na ba yung pera? Siyempre, hindi. Okay? Magkakaroon that time, at that moment na nasingil niya na lahat, at that moment, si Z magkakaroon na ng obligation. Kanino? Sa kanyang mga co-solidary creditors. So, magkakaroon siya ng obligation to reimburse Y, X, and Y ng kani-kanilang mga shares, which is 63,000. So, yung nasingil niyang 9,000, yung nasingil niyang 9,000, 3,000, ibibigay niya kay X. At another 3,000, ibibigay niya kay Y. Ilan yung natira sa kanya? Tama, 3,000. Tama. Okay, so, pantay-pantay rin lang. Parang kumbaga, ultimately, magiging pantay-pantay din ng lahat. Okay? Pero, sa mode of collecting the debt, kahit sino sa kanila, pwedeng maningil nung lahat ng utang. Okay? So, next. Okay, this time, ano to? Okay, ano yung example natin kanina? Okay, so nagtatanong this time, same example pa rin, how many distinct debts? So, there are only 3 debts. So, ano yung mga yon? Okay, ito, magandang pagkakasabi dito. A pays X, Y, or Z 3,000. Okay? B pays X, Y, or Z 3,000. And C pays X, Y, or Z 3,000. Okay? So, ayan. Next example. Ang next example natin ay... okay. So, this time, ang solidary ay debtor. At ang creditor ay... Tama. Joint. Kasi walang binanggit. Okay? So, take note of this. The binanggit. Solidary debtors. Okay? So, ayan. So, same, How much is the share of A, B, and C in the debt? So, ganun pa rin? 3,000 pa rin? Walang pagkakaiba? Pero, actually, ang may effect is yung, ang merong effect dun sa, kung magkano. Okay? Kung magkano yung obliged silang bayaran. So, mamaya, illustrate natin. How much is the share of X, Y, and Z in the debt? So, ganun pa rin? 3,000? Okay, so, yan. How much is B liable to pay? Okay. Being a solidary debtor, he is liable to pay the whole obligation. So, that is 9,000. Kasi solidary, the whole obligation. How much can Z collect? So, yung kanyang share lang, 3,000. Kasi naging joint ulit, di ba? Okay. How much is B liable to pay X? B is liable to pay, okay, actually, B is liable to pay the whole obligation, di ba? Pero, dahil binanggit natin, nagbanggit tayo ng isang specific creditor, at yung creditor na yan kasi ay joint, ibig sabihin na pwede niya na masingil ay yung kanyang share, so hindi mo pwedeng bayaran lahat. Okay, so meaning, ibayad mo lang yung 3,000, yung kanyang share lang. Okay? Pero maya-maya, pwede kang singilin ulit ni Y. Pwede kang singilin ulit ni Z. Pwedeng lahat ng joint creditors maningil sa isang joint debtor lang, which is si B. So, all in all, si B, 9,000 lahat ang binayaran niya, okay? Which is tama lang kasi under solidarity debtors, di ba? Obliged kang bayaran lahat. Okay? So what if nabayaran lahat ni B yung utang, di ba? Yung buong 9,000. So 9,000 ang naging outflow niya. This time, meron siyang magkakaroon siya ng right to demand reimbursement from A and C. Okay? So, magpapa-reimburse siya ng, ayun. Okay? Magpapa-reimburse siya. Mali yung nabanggit ko pala kanina na term. Sabi ko si Y, si Z, i-reimburse niya si X and Y. Mali. Si Z, ano tawag dito? What do you call this? I-distribute niya yung nasingil niyang 9,000 kay X and Y. Okay? So, this time pero, si A and C, babayaran nila si B. Kapag binayaran lahat ni B yung 9,000, i-reimburse ni A and C yung kani-kanilang mga share, which is 3,000 each. Okay? So, meron tayong second question dito. How much can Z collect from A? That is 3,000. Simple lang kasi si Z ay isang joint creditor. So, therefore, ang kanyang pwedeng singilin lang ay up to kanyang share, which is 3,000. Okay? So, ayan. Next question. How many distinct debts are there? There are only 3 debts. First is A, B, or C pays X 3,000 and so on. Okay? So, nabaliktad this time. Kanina, dahil solidary yung creditor, sila yung X or Y or Z. Di ba? Pero this time, dahil debtors naman ang solidary, sila naman na yung or. Okay? So, i-analyze nyo yan. Assignment nyo yan kung bakit ganyan ang pagkaka-construct natin ng mga different, ng mga distinct debts. Okay. Okay, so ano yan? Okay, so medyo... Okay, so ayan. This time, both parties or both sides are solidary. Okay. So, how much is the share of A, B, and C and the debt? So, ganun pa rin, 3,000. Hindi naapektuhan yung share. Inulit ko. Whether they are solidary or joint, hindi naapektuhan yung share. Kung ano yung naitalagang share nila, yun. Okay? So, kung walang nabanggit, equally sila. Okay. Ang maapektuhan is yung pwede nilang, yung obliged silang bayaran at pwede nilang singilin. Okay. So, how much is B liable to pay? So, 9,000 dahil solidary. How much can Z collect? So, ganun din. Medyo mali. Okay. So, how much can Z collect? That will be 9,000. So, mali ito. 9,000 dahil solidary. Okay. Hindi natin na edit. Okay. So, how much is B liable to pay X? How much is B liable to pay X? So, magkano ang babayaran nga ba ni B kay X? Okay. Dahil sila ay parehong solidary, si B solidary, si X solidary, 9,000. Okay, so mali. Mukhang na-copy-paste natin yung example kanina dun sa solidary tapos Okay, so this is 9,000. Okay. Yan na lang natin. Hindi natin na-edit yung PowerPoint. Okay. So, 9,000. So, how much can Z collect from A? Okay. So, magkano ang pwedeng kolektahin ni Z from A? Again, this is 9,000. Kompleto na. Okay. So, ganito. If ever may mangyari dun sa ito or ito, let's say, si X nakasingil kay B ng 9,000. So, ang nangyari is, si X, nasingil niya lahat, pati yung share ni Y and Z. So, meron siyang obligation na ibigay yung share ni Y and Z. On the other side, binayaran ni B kay X, di ba? So, nagkaroon ng so, nabayaran niya na rin yung share ni A and C. So, si B magkakaroon ng right to claim reimbursement from A and C, which is 63,000 para yun. Sinasabi ko nga, whether joint, solidary, it doesn't matter. Parang kumbaga, ultimately, in the end, yung share pa rin ang ultimately babayaran mo at ultimately masisingil mo. Okay? Nagkaroon ng effect whether it is a joint or solidary in terms of paniningil at pagbabayad dun sa mode of paying at mode of collection. Okay? So, ayan. So how many distinct debts? There are actually one debt only, which is yun, or pareho. So A, B, or C pays X, Y, or Z 9,000. So buong 9,000 yan. Okay? So ayan. Let's proceed to the next article. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the others shall not be liable for his share. Okay. Ano ang ibig sabihin dito? So, division is impossible. The right of the creditors may be prejudiced by their collective acts. Okay. So, ayan, tawag dito, nagsingit tayo ng joint indivisible obligation. Okay? Sige, illustrate natin to. A, B, and C are jointly liable to give D a car. On the date of delivery, A and B are willing to deliver, but C is not. Okay? So, si C, hindi siya willing i-deliver yung car. Kung mapapansin natin, kung kanina kasi, yung mga examples natin, pagbabayad lang ng pera, so walang problema. Okay? Kung hindi willing si C na magbayad ng kanyang share, walang problema kasi yung paniningil naman, yung pagbabayad naman, kanya-kanya di ba? A, babayaran nyo yung utang niya, ganun si B, di ba? Yun lang yung oblige, yung up to the share niya lang, yung kanyang oblige na bayaran kapag joint. Diba? Pero, in this case, medyo iba tong example na to. Bakit? Kasi ang ating prestation ay hindi divisible. Unlike money. Unlike a prestation to give money, which is divisible. Diba? This time, it's to give or to deliver a car. Okay? Which is physically impossible to be divisible. Diba? To divide. So, ibig sabihin, hindi naman pwedeng i-deliver ni A and B yung 2/3 nung car. Tapos yung 1/3 maiwan kay C. Bahala ka dyan. Parang ganun. So, hindi naman pwede yun. Okay? So, in this case, ang tanong, okay, ito ang tanong. Can A and B validly deliver the whole car to D? Okay? Can A and B validly deliver the whole car to D? Which is the, di ba? Which is the creditor in this case. The answer. Okay, what's the answer? Okay, ano ba yan? Okay. So, the answer is no. Okay? A and B cannot validly deliver the whole car to D. Kasi kailangan ng kailangan ng willingness ni C. Yun yung sinasabi ng article yung kanina, 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all debtors. If one of the latter should be insolvent, the other shall not be liable for his share. Okay. Okay, itong last sentence naman, medyo kakaiba. So, balik tayo pag pera ang usapan. So, for example, balik tayo dito. Let's say ito. Balik tayo dun sa joint, yung may joint debtor. Okay. Medyo malayo pala. Dami palang ano. Okay. So this time, okay, ito joint debtor. A, B, and C are bound to pay solidarity creditors XYZ. Okay. So kung naging insolvent si C, wala tayong pakialam. Walang pakialam si A and B. Kung kayang makabayad ni A and B ng kanilang mga share, which is 3,000 in this case each, di ba? So, wala tayong problema doon. So, si A and B, magbabayad ng kanilang mga share, which is 3,000. Hindi pwedeng singilin ng mga creditor si A and B sa share ni C. Kasi hindi sila makasingil kay C. Bakit? Kasi insolvent si C. Hindi nila pwedeng singilin si A and B. Tapos, saka na lang sila magpa-reimburse kay C. Hindi po pwede yon kapag joint. Okay? Pwede lang yun kapag solidary yung mga debtors. Okay, yun yung sinasabi nung last sentence doon sa article na yun. Okay? So, let's proceed to the next article. Okay. Okay, mahaba na naman. Okay, marami tayong error sa PowerPoint. Hindi natin na-check mabuti. Okay. So, next, 1210. The indivisibility of an obligation does not necessarily give rise to solidarity, nor the solidarity of itself imply indivisibility. So, ang gusto lang sabihin nito, hindi porkit solidary liable whatsoever, ganun, automatically indivisible yon. Hindi po. Okay? Hindi po ganun yon. Okay? Depende pa rin sa tawag dito, intention. Okay? Intention ng mga parties kung ano yung prestation. Kasi ibang indivisibility, pag sinabi natin kasing indivisibility, it refers to the prestation. However, solidarity or yung pagiging joint refers to the what? To the juridical tie of the subjects, which are the passive subject or the active subjects, or simply the creditors and the debtors. Okay? So next, 12.11. What is 12.11? So, solidarity may exist although the creditors and debtors may not be bound in the same manner and by the same periods and conditions. So, ano ito? Okay, so as an example, okay, ito yung example natin sa 12.11. A, B, and C, or A, B, C, and D oblige themselves solidarily to pay E 20,000 as follows. Si A, yung kanyang share ay ito. Okay? A to pay by installment at the rate of 1,000 a month. Okay? To start in July. Okay? To start in July daw. Okay? So, assuming, okay, hindi malinaw kung paano yung pagkakahati. So, malamang yung 20,000 ay paghahati-hatian nilang apat. So, kung apat sila na maghahati-hati sa 20,000, ilan yun? 5K. Tama? 5K. So, ibig sabihin, July, August, September, October, November. Hanggang November siya magbabayad. Okay? So, July, August, September, October, November. Tama. So, ayan. Si B naman, obliged siya na magbayad on September. Malamang-lamang, walang binanggit. Basta magbabayad siya ng September o magbabayad siya ng 5K sa September. Ganon din si C, 5K dito. Okay? Ito naman, medyo kakaiba yung kay letter D kasi if E passes the bar exam. Okay, sino ba si E? Ito, si E, siya yung creditor. So, ito, conditional. So, yung 5K conditional. Ibig sabihin, may chance na hindi masingil tong 5K na dulo na ito. May chance na ang masingil lang ni E ay 15,000, okay? So, ang tanong is, ano ang kinalaman nito dun sa naunang article na sinasabi natin? Okay, pag binasa natin ulit, sabi niya dito, pwede pa rin maging solidary, okay? Although the creditors and debtors may not be bound in the same manner by the same periods or conditions. So, kung mapapansin nyo, obviously, they are not bound by the same periods and by the same conditions. Okay? So, si A, B, and C are bound by periods pero magkakaibang periods. While si D is not bound by a period at all. He is bound by a condition. Okay? So, anong effect nun? So, ganito. So, mag-i-start na magkakaroon ng pwedeng singilin si E from July, tama? So, sa July, from among this lahat, itong lahat na to, sa July, magkano pwedeng singilin ni E? Ang pwedeng singilin ni E, syempre, ang magjuju pa lang ay 1,000, tama? Okay? Ang magjuju pa lang, pagdating ng July, ay 1,000. Pero ang tanong, kanino niya pwedeng singilin yung 1,000? Okay. So, dito na magte-take effect yung sinasabi ng article. Sabi niya, solidarity may still exist. Okay? Meaning, yung 1,000, pwede niyang singilin kay A, pwede rin kay B, kahit na hindi niya yung share, inuulit ko, di ba? Kasi solidary sila eh. Pwede rin kay C, pwede rin kay D. Okay? So, nag-exist pa rin ng solidarity. Okay? So, pagdating ng July, August, okay? So, pagdating ng August, another 1K, di ba? Another 1K ang demandable. So, inuulit ko yung another 1K na yan, pwede niyang singilin whether kay A, kay B, kay C, pwede niyang pag-initan si D na, pwede niyang singilin lahat si D. Okay? Pero maya-maya, syempre, si D, pwede siyang magpa-reimburse from A, B, and C. Di ba? Okay? So, pagdating ng July, August, September. Okay, so pagdating ng September, ang total due ay 1,000 plus yung 5,000 ni B. Tama? Okay, so totaling 6,000. Yung 6,000, kanino niya pwedeng singilin? Inuulit ko, ganun pa rin. Whether kay A, whether kay B, whether kay C, whether kay D. Kasi solidary sila. Okay? At syempre, wag nyo na akong tatanungin kung paano pagdating ng December yung 5,000, ganun pa rin. Pwede niyang singilin yung 5,000 na yan ulit, whether kay A, whether kay B, whether kay C, whether kay D. At ganun din dun sa dulo. Kapag sakaling pumasa ng bar exam si E, malamang-lamang magiging demandable na yung share ni D. Pero, yung 5,000 na share niya na yan, pwedeng singilin kahit kanino sa mga solidarity debtor. Okay? So, next, Article 12.12. So, each one of the solidarity creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. So, let's give an example. Okay. So, example, A owes B and C solidarity creditors. So, ang solidarity creditor si B and C, okay? So, the sum of 20,000. The sum of 2,000, okay? So, an example of an action that is beneficial to the other is if either B or C demands the obligation from A. Kasi, kung binalikan natin ng Chapter 2, Nature and Effects of Obligation, syempre mag-a-apply dito ang no demand, no delay. So, as much as possible, gusto natin na masingil na yung obligation, syempre. So, actually, pagdating sa solidarity creditors, kahit sino sa kanila pwedeng mag-demand. Okay? Either sa B or si C pwedeng mag-demand. Okay? Nung buong obligation. Okay? So, that is an action beneficial to the other solidarity creditor. What about an example of an action prejudicial to the other? If either B or C renounces the entire obligation. So, kapag ni-renounce ni B yung entire obligation, malamang-lamang pag sinabi natin ni-renounce, anong ibig sabihin yan? Ni-remit or parang dinonate na, hindi na pinabayaran kay A. So, malamang-lamang, kapag ni-renounce ni B yung kanyang, what do you call this? Yung buong 2,000, malamang-lamang affected pati yung share ni C. Pati si C hindi na makakasingil. Okay, pero si C, meron pa rin siyang right to demand his share from B, which is 1,000 kasi hindi naman siya nag-consent dun sa renunciation if ever ni-renounce ni B. Okay? Ganon din kapag si C ang nag-renounce. Si B meron siyang right to demand his share. Okay? So next, Article 12.13. A solidarity creditor cannot assign his right without the consent of the others. So anong ibig sabihin nito? Hindi niya pwedeng i-assign. Pag sinabi natin i-assign, ibigay sa ibang tao yung kanyang right. So for example, meron yung kaninang pinag-uusapan natin, yung creditors XYZ na meron with regards to 9,000 na debt. So yung share doon ni A, which is ni X, let's say, which is 3,000, hindi niya pwedeng i-assign yun kay, let's say, kay W, di ba? So hindi niya pwedeng i-assign yun. Okay, without the consent of the other solidarity creditors. Parang partnership din lang yan, di ba? Actually, ang solidarity parang partnership. Okay? Sa partnership, di ba, hindi pwedeng tawag dito, hindi pwedeng tumanggap ng additional partner without the consent of all the other partners. Ganun din kapag yung sa assignment, di ba? Hindi pwede. Okay? So, Article 12.14, the debtor may pay any one of the solidarity creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. Okay? So, ang sinasabi lang ni Article 12.14, ang isang debtor pwedeng magbayad sa kahit kaninong solidarity creditor. Pero once na merong nagdemand, dapat doon siya magbayad. Okay? Kasi kung may nagdemand, tas nagbayad siya doon sa isa, hindi yun valid payment. Okay? Hindi yun valid payment yung ginawa niya. Okay ba? So, that is Article 12.14. Okay, so ayan, may example pala tayo. A owes B and C solidarity creditors the sum of 2,000. On due date, B demanded the obligation from A. However, A ended up paying C. So, sabi ko nga, hindi valid yung ginawang payment dun ni A. Kasi naunang nag-demand si B. Okay? So, ayan. 12.15. Novation, compensation, confusion, or remission of the debt made by any of the solidarity creditors or with any of the solidarity debtors shall extinguish the obligation without prejudice to the provisions of Article 12.19. The creditor who may have executed any of these as well as he who collects the debt shall be liable to the other for the share in the obligation corresponding to them. Okay, example, D owes A, B, and C. So, si A, B, C, mga solidary creditors, the sum of 3,000. If C remitted the entire obligation without A's consent, the obligation will still be extinguished. Tama, may extinguish. Wala nang babayaran si D. However, C is liable to A and B with regards to their respective shares. So, simple lang. Okay? Actually, parang nabanggit ko yan kanina. Okay? So, ito pala yun, yung specific article na pinag-a-applyan niya. Okay. So, ayan. 12.16. The creditor may proceed against any one of the solidary debtors or some or all of them simultaneously. So, kapag may mga solidary debtors, let's say solidary debtors A, B, C, pwede na pwedeng singilin, let's say pwedeng singilin from only one of them yung whole obligation kasi nga yun nga solidary debtors sila, or pwedeng all of them. Okay, singilin ko na kayo lahat, pwede. Okay, so the demand made against one of them shall not be an obstacle to those which may subsequently be directed against the other, so long as the debt has not been fully collected. Okay, so I believe meron tayong example dito. Okay, mukhang wala. Okay, so okay, tingnan natin. Okay, mukhang wala. Okay. The demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as... okay. So, ang gusto lang sabihin dito is, for example, ako na, kunwari, let's say, meron tayong solidary debtors A, B, C. Let's say, meron lang nag-iisang creditor, which is si X, di ba? So, kapag nag-demand si X from A, okay, pero hindi pa siya nakasingil, okay, the demand made against one of them shall not be an obstacle to those which may subsequently be directed against the others, so long as the debt has not been fully collected. So, ang nangyayari is, pwede pa rin singilin ni X si B or si C. So, if ever sakaling nagbayad si B, okay, kay X, let's say yung full obligation, wala nang problema, di ba? Pero what if nagbayad pa rin si B, hindi whole obligation, let's say 1/2 lang yung binayaran niya. Hindi pa rin titigil sa paniningil si X. Pwede pa rin siyang punta kay C. Okay, para singilin yung natitirang obligation. Okay? Pwede na lang siyang tumigil, or, di ba? Wala na siyang right para maningil if nasingil niya yung buong obligation. Has been fully collected. Di ba? Siyempre, obviously, dapat na siyang tumigil. Wala na siyang pwedeng masingil kasi nasingil niya na lahat. Okay? So, 12.17. Payment made by one of the solidary debtors extinguishes the obligation. If two or more solidary debtors offer to pay, the creditor may choose which offer to accept. Okay, so very straightforward naman siguro to. So, dalawa yung nag-offer na magbabayad. So, kay creditor kung kanino yung i-accept. He who made the payment may claim from his co-debtors only the share which corresponds. Ito yung sinasabi ko kanina. For example, binayaran ng isang debtor yung kanyang di ba? Yung lahat ng utang, meron siyang right to claim from his co-debtors. Okay, which corresponds to each with the interest for the payment already made. If the payment is made before the debt is due, no interest. So, malamang siguro i-straight natin yan. When one of the solidary debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all of the... Okay, so parang partnership lang to actually itong last paragraph na to. So, yan natin. X, Y, and Z solidary debtors owe C the sum of 3,000. The debt is due December 31 the current year. If both X and Y offer to pay C on December 31, the latter may choose which offer to accept. Okay, so yan natin. Extend natin yung example. So, explain din natin yung second paragraph. Okay. So, assuming binayaran ni Okay. So, assuming ang offer na inaccept ni C ay yung offer ni X. So, si X, nagbayad siya ng buong 3,000. So, in this case, si X, magkakaroon siya ng right to demand from Y and Z, di ba? Reimbursement of 1,000 pesos each. Tama? Okay. Pero what if, ganito? If, what do you call this? Sabi niya dito, okay. So, if nagbayad si X sa tamang time, let's say December 31 the current year, okay, tama? Tapos, naniningil siya, nagka-claim siya ng reimbursement from Y and Z, pero hindi nakapagbayad kaagad si Y and Z, pwedeng mag-accrue ng interest. Okay? So, yun yung sinasabi dito. Okay? Each with the interest for the payment already made. However, if the payment is made before the debt is due, no interest for the intervening period may be demanded. So, what if ganito? Nagbayad si X ng November 1 ng previous year. Okay, so, merong 2 months. Okay? 2 months na early, di ba? 2 months earlier. Okay? 2 months earlier na nagbayad. So, yung 2 months earlier na yan na nagbayad si X, hindi ka pwedeng mag-accrue ng interest dyan if ever hindi makabayad agad si Y and Z. Kasi in the first place, December 31 pa naman mag-mature yung utang. Okay? So, if ever maaga nagbayad si X, kung magka-claim man ng reimbursement from Y and Z, hindi siya pwedeng mag-accrue ng interest dun sa intervening period, which is the November 1 to December 31. Okay? So, yun. And lastly, when one of the solidarity debtors cannot, because of his insolvency, reimburse his share to the debtor paying the obligation, such share shall be borne by all his co-debtors in proportion to the debt of each. Okay. So, ayan. Binayaran ni X yung buong 3,000. Magkano pwedeng singilin niya from Y and Z? Siyempre, yung mga respective share nila, tigwa 1,000. Pero what if si Z, at the time of naniningil na si X ng reimbursement, insolvent siya. So, ang mangyayari is, malamang hindi makakabayad si Z. Pwedeng singilin ni X yung portion ng hindi niya masingil kay Z from Y. So, magkano yun? Okay? So, ganito. Si X, nagbayad ng 3K. Si Y and Z, kailangan nilang mag-reimburse ng tigwa 1K. Okay? 1K papunta kay Y. Okay? Para all in all, lahat sila ang binayaran tigwa 1K. Pero what if si Z? Hindi kasi insolvent. Yung 1K ni Z, paghahatian ni X and Y. Kasi, bakit paghahatian? Kasi, pares lang naman yung share nila. 1K, 1K. So, yung proportion, hati lang sila. So, meaning, ganito. Kapag magpapa-reimburse na si X, ang pwede niyang mapa-reimburse kay Y ay 1,500. Yung 1,500 composed of 1,000 na share ni Y at 500. Okay? Na share ni Y from the insolvency of Z. Okay? Tandaan, si X may share din sa insolvency ni Z. Kaya nga, 1,500 lang ang pwede niya masingil eh. Ibig sabihin, all in all, ang binayaran nila pareho ay 1,515. Okay, naghati sila dun. Okay? So, next, Article 12.18. Payment by a solidarity debtor shall not entitle him to reimbursement from his co-debtors if such payment is made after the obligation has prescribed or becomes illegal. So, yun. Simple lang. So, ayan. Okay, ano yan? Ito ba yun? Okay. So, may example pala tayo dyan. Okay? X, Y, and Z, solidarity debtors, owe C the sum of 3,000. The debt is due December 31 current year. On the due date, C did not demand the payment. C also failed to demand the obligation for the next 15 years. Grabe. Okay, so by the way, according to the civil code, kapag ang isang debt ay hindi na siningil, okay, for a period of more than 10 years, in case of written, okay, so assuming written to, in case of written obligation or contract, it will prescribe. Pag sinabi natin magpe-prescribe, magiging ano na siya, parang kumbaga, ma-extinguish na yung obligation mo, okay? So in this case, nag-prescribe na siya, Okay? So, ang nangyari, after which, Z, pero, despite the prescription, nagbayad pa rin daw si Z ng 3,000. Although it was known to him that the debt already prescribed. Nagbayad pa rin si Z kay C ng 3,000 kahit na nag-prescribe na yung utang. Ang tanong, si Z ba, pwede siyang mag-claim ng reimbursement from X and Y, which is naturally yun ang nangyayari sa isang solidary debtors? The answer is no. Okay? Because according to Article 12.18, hindi na pwedeng magpa-reimburse from his creditors if such payment is made after the obligation has prescribed or becomes illegal. Okay? Very straightforward lang po yun. Next, Article 12.19. So, last na ba to? Mukhang marami pa. Okay, so 12.19. The remission made by the creditor of the share which affects one of the solidary debtors does not release the latter from his responsibility toward the co-debtors in case the debt has been or had been totally paid by any one of them before the remission was effected. Okay? So, simple lang ito. Kapag niremit ang share ng isang solidary debtor, hindi ibig sabihin na mawawala na rin siya as a solidary debtor. Liable pa rin siya as a solidary debtor. So, let's explain. So, in this case, XYZ, solidary debtors, si C ay isang creditor. So, C, thereafter, renounce the share of Z. So, na-renounce yung share ni Z. Pero ang tanong, dahil ba na-renounce yung share ni Z, hindi na ba siya solidary debtor? The answer is no. Solidary debtor pa rin siya. Ibig sabihin, pwede pa rin singilin si Z na magkano? Siyempre, na-renounce yung kanyang share, malamang-lamang, yung share niya dito is 1,000. So, ang matitira na lang dun sa obligation ay 2K. So, on due date, si C, pwede pa rin mag-demand ng payment from Z. For how much? 2K. Pero, siyempre, may right si Z, which is to claim reimbursement from X and Y. So, magka-claim siya ng 1,000 each. Okay? Ultimately, wala pa rin siyang binayaran. Tama? Okay? So, sana naintindihan nyo yun. Yun yung example ng 12.19. What if naman? Okay, so this time, 12.20. The remission of the whole obligation naman in favor of one person obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. Okay, so ayan, same example tayo, pero this time, hindi lang yung kanyang share ang nirenounce. Nirenounce yung buong obligation in favor of Z. So therefore, yung 3,000, wala nang matitira kasi nirenounce yung buong obligation. Pero ang tanong, pwede bang mag-claim ng reimbursement si Z? Okay, so meron tayong quotation mark kasi reimbursement kasi wala naman talagang papa-reimburse kasi wala naman siyang binayaran. Okay, so pwede ba? Pwede pa rin ba yun? The answer is no, because the remission of the entire obligation in favor of a solidary debtor extends to the benefit of the other solidary debtors, which is C, X, and Y. So, hindi niya na pwedeng singilin yung mga yan. Maungla, parang kumbaga, tutubo siya ng 2,000. Okay, 2,000. Okay, so 12.21. If the thing has been lost, or if the prestation has become impossible without the fault of the solidary debtors, the obligation shall be extinguished. So, very simple. Nag-root out from the principles ng Chapter 2, Nature and Effects of Obligation. If there was fault on the part of any one of them, all shall be responsible to the creditor. Kasi, solidary, di ba? Solidary. So, kahit sino sa kanila, mananagot, di ba? For the price and the payment of the damages and interest without prejudice to their action against the guilty or negligent debtor. Pero, syempre, pagdating ng reimbursement, ultimately, ang magbabayad lang nun, syempre, yung pinaka may fault kung sino man sa kanila, okay? So, mamaya, yan natin yan, kung meron man tayong example. So, if through a fortuitous event, the thing is lost or the performance has become impossible after one of the solidary debtors has incurred in delay through the judicial or extrajudicial demand upon him by the creditor, the provisions of the preceding paragraph shall apply. So, anong sinasabi nitong third paragraph? Medyo nagulo. Has become impossible after one of the... Okay. So, kahit na fortuitous event daw yan, kapag meron ng delay, okay, ganito pa rin, okay? Ganito pa rin sa second paragraph, okay, of the preceding paragraph, sabi niya, shall apply. Okay, ganito pa rin yung rule natin dyan. Okay? Which is tama kasi according to, yun nga, chapter 2 ulit, nature and effects, may exemption yung 427, di ba? Kapag delay na, hindi na mag-a-apply yung rule ng 427 which is no one shall be liable, di ba? In case of 427. Okay, so example, X and Y, Z, solidary debtors, are obliged to deliver to C a specific monkey. Okay, so itong specific monkey na it is, to deliver specific monkey is an indivisible prestation, di ba? Consider the following situations. The monkey was struck by a lightning. So that is, I believe, the first paragraph. So kapag, okay, naging impossible without the fault, so that will be extinguishment of the obligation. Number 2, through X fault, the monkey was killed. Okay. So, ang mangyayari is, their obligation will be converted into a monetary obligation. So, magiging value of the monkey plus damages ito. Okay, magiging value of the monkey plus damages. Yun yung pwedeng singilin ni Z kahit kanino sa kanila kasi solidary debtor sila. Pero, pagdating sa reimbursement, ang magbabayad lang ng damages ay si X in this case. Kasi siya yung may fault. Okay ba? Ang babayaran ni Y at si Z ay yung kanilang share lang. So, for example, ang monetary value ng monkey ay 9,000. Okay? At ang damage ay let's say 1,000. So, all in all, 10,000. Ang babayaran ni X ay yung share niya sa 9,000 which is 3,000 plus yung damages. So, all in all, 4,000. Si Y and Z naman yung share lang nila na 3,000. Okay? So, next, number 3. When the obligation was due, C demanded the delivery but no one was able to deliver the said monkey. After a few days, the monkey was struck by lightning. Okay. Ito yung third paragraph. Ito yung kahit na for 327 pero may delay. Okay? May demand na eh. May demand na. So, walang nag-comply. So may delay. Okay? So, ang magiging rule natin, parang ganito. Sa number 2. Pero, anong pagkakaiba ng number 2 at number 3? Anong pagkakaiba? Ang pagkakaiba, sa number 3, lahat sila may fault. So, ibig sabihin, yung 1K, if ever 1K yung damages, paghahatian nilang tatlo yung 1K. Okay ba? Unlike sa number 2 na isa lang may fault, which is siya ang magbe-bear lahat ng ano. Okay? So, ganun yung illustration natin dyan sa Article 1221. So, what is Article 1222? Ano ito? A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation and of those which are personal to him or pertain to his own share. With respect to those which personally belong to the others, he may avail himself thereof only as regards that part of the debt for which the latter are responsible. Okay, so para mas maintindihan natin, let's illustrate. So, X, Y, and Z are solidary debtors of C for the amount of 100,000. Okay? Assuming the debt already prescribed. Okay. Ang magiging defense, let's say, mamili tayo. Pag sinisingil ni C, si Y, ang pwede niyang maging defense ay nag-prescribe na yung debt para hindi bayaran. Tama? Which is a valid defense. This defense is based on the nature of the obligation. Because the obligation is no longer existing. It's no longer a civil obligation kasi nag-prescribe na. Okay? So in this case, Y's defense is based on the nature of the obligation itself. Which is, yun, hindi mo ako pwedeng singilin. Wala na akong obligation kasi nag-prescribe na yung debt. Okay? So, yun yung sinasabi dito. Di ba? A solidary debtor may, in actions filed by the creditor, avail himself of all defenses which are derived from the nature of the obligation. So, as an example, yung prescription, isang defense yan. Number 2, assuming Y is a minor. Okay. So, minority is also a defense. Pero hindi siya based on the nature of the obligation. It is based on person. Okay? It is personal to Y. Okay? It is personal to Y. Itong defense na to, hindi pwedeng maklaim ni X or ni Z. Kasi hindi naman sila minor. Ang pwede lang makaklaim nito ay si Y. Okay? So, yung defense na ito ay personal to Y only. Pero, this is a complete defense. Ibig sabihin, hindi siya pwedeng singilin. Completely. Hindi siya pwedeng singilin. Okay? Nung 100,000. Okay ba? Okay. Next, number 3. Assuming Y's share is dependent upon a condition. What is the defense? Okay? In this case, pwedeng maging defense ni Y if hindi nangyari yung condition. Okay? Pag hindi nangyari yung condition, let's say, ang share ni Y dun sa 100,000 ay, let's say, 30K. Okay? Hindi nangyari yung condition. Sinisingil siya ni C ng 100,000. Pwedeng niyang erase yung defense na hindi nangyari yung condition with regards to my share. So, therefore, hindi ka dapat maningil ng 100,000. Maniningil ka lang dapat ng 70,000. Okay? So, yun lang yun. Di ba? Pero in this case, unlike sa number 2, number 3 is a personal defense. However, it is only a partial defense. Bakit? Hindi nyo na-mitigate yung buong 100,000 eh. Unlike the defense of minority in number 2, wherein hindi siya pwedeng singilin lahat. Yung buong 100,000, hindi siya pwedeng singilin. Pero sa number 3, partial defense lang siya kasi portion lang ng 100,000 yung affected by the defense. Okay? So, yun yung Article 1222. Okay? So, in this case, dito mag-e-end yung ating joint and solidary obligations. Okay? So, next, let's go to divisible and indivisible obligations. Okay? So, divisible and indivisible, ayan, yan yung summary ng babanggitin natin dito. Okay, so 1223, the divisibility or indivisibility of the things, okay, medyo, mouse slip, okay, that are the object of the obligation in which there is only one debtor and only one creditor does not alter or modify the provisions of Chapter 2 of this title. Okay, so simple lang, kung ano man yung mga nabanggit sa nature and effects of obligations, kasi kung nung nag-example tayo doon sa Chapter 2, ang assumption, ano ba yun? Hindi natin distinguish whether the prestation are divisible or indivisible, pero sinasabi sa 1223, it doesn't affect. Okay? Whether it is divisible or indivisible, lahat ng nasa nature and effects, susundan pa rin natin yun. Okay? Next, a joint indivisible obligation gives rise to indemnity for damages. From the time any one of the debtors does not comply with this undertaking, the debtor, who may have been ready to fulfill their promise, shall not contribute to the indemnity beyond the corresponding portion of the price of the thing or of the value of the service in which the obligation consists. Okay, so example. Kung maalala nyo, in example natin ito, kanina kasi ang example dito yung solidary, pero this time, joint. Okay, joint tayo this time. Kanina, solidary indivisible obligation. This time, joint indivisible obligation. Okay, so anong pagkakaiba? Okay, so XYZ, debtors are obliged to okay. Consider the following situations. The monkey was struck by lightning, so parehas din. Extinguishing obligation. Number 2, through X fault, the monkey was killed. Okay, so in this case, so paano ba yun? Si C, okay, dahil solidary debtor si X, Y, and Z, ang pwede niyang singilin, or ang mode, or ang proseso, or ang method, kung paano maningil si C, ay isa-isa. Hindi niya pwedeng singilin ng isa, tapos magpa-reimburse na lang. Sa solidary yon. Kasi joint to, iba siya this time, kasi joint to, di ba? So si C, maniningil siya kay Y, maniningil siya ulit kay Y, kay X, kay Y, maniningil din siya kay Z. Okay? Iba-iba. Pero this time, okay, number 2, tingnan natin. Through X fault, the monkey was killed. Okay? So, yung obligation nila, which is an indivisible obligation to give a specific monkey, makukonvert siya into a monetary obligation. So, let's say 9K yung specific monkey, tapos plus damages na 1K. Okay? Magkano pwedeng singilin ni C? Kay X, that will be yung share ni X from the 9,000, 3,000 plus 1,000. Ganun din kay Y. Okay? Kay Y pero walang 1,000. Siyempre, kasi si X lang yung may fault eh. Okay, so ang masisingil ni C kay Y ay 3,000. At ang masisingil ni C kay Z ay 3,000 din. Okay? Yung kanina, yung example natin kanina, solidary yun. So therefore, si C, pwede niyang singilin yung buong 10,000 Whether kay X, kay Y, or kay Z. Pero magre-reimburse na lang sila, di ba? Pero ultimately, ganun pa rin. Ang babayaran ni X ay 4,000. Okay? Kasi siya lang yung may fault kung bakit namatay yung monkey. And number 3, in this case, fault nila to lahat. So, ang pwedeng singilin ni C ay 3,333 kay X, ganun din kay Y, 3,333, at ganun din kay Z, 3,333. Pinaghati-hatiin nila lahat yung damages, okay? For your information. Okay, next, Article 1225. For the purpose of the preceding article, obligations to give definite things and those which are not susceptible of partial performance shall be deemed to be indivisible. When the obligation has for its object the execution of a certain number of days of work, the accomplishment of work by metrical units or analogous things which by their nature are susceptible of partial performance, it shall be divisible. Okay, continued. However, even though the object or service may be physically divisible, an obligation is indivisible if so provided by law or intended by the parties. An obligation not to do, divisibility or indivisibility shall be determined by the characters of the prestation in each particular case. Okay, so in determining divisibility and indivisibility, we refer to the intention of the parties. Okay, so for example, D is liable, or si D meron siyang utang kay C for the amount of 20,000, although money is divisible, pero yung specific obligation na yon, ang intention doon ay bayaran yung 20,000 at a certain maturity date for the whole amount of 20,000. So, in terms of intention, that will be indivisible. Okay? Unless merong terms, which is, let's say, gumawa tayo ng installment term doon sa pagbabayad ng utang. So, that will be a divisible obligation in that case, di ba? Okay, so, in determining divisibility and indivisibility, mananaig ang intention ng parties. Okay ba? Okay. So, next. Okay, pupunta na tayo sa last type of obligation, which is an obligation with a penal clause. So, when we say obligation with a penal clause, ito yung mga obligation na kapag hindi mo nagawa yung obligation, mayroong penalty. Okay, so in obligation with a penal clause, the penalty shall substitute the indemnity for damages. Okay, so and payment of interest in case of non-compliance. Di ba pag hindi mo nagawa, laging sinasabi natin, magbabayad ng damages plus interest, okay? Pero kapag may penalty, okay, ang general rule, okay, yung penalty na yun. Yung damages yun na yun, yung penalty, okay? So, if there is no stipulation to the contrary, nevertheless, damages shall be paid if the obligor refuses to pay the penalty or is guilty of fraud, blah, 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 in the fulfillment of the obligation. The penalty may be enforced only when it is demandable in accordance with the provisions of this code, okay? So, dito, sa specific article na to, nagawa natin tong general rule na to and exemptions. So, general rule, penalty serves as a substitute to damages and interest. So, ano yung mga exemptions? 3. When there is a stipulation to the contrary, ibig sabihin, yung kontrata, sabi niya, in addition to penalty, kailangan pa rin magbayad ng damages and interest. Number 2, the debtor refuses to pay the penalty. And number 3, the debtor is guilty of fraud. So, yan yung mga exemptions. Okay. So, ano tong 1228? So, hanggang ano tayo? Okay, so, ano tayo? 1227. Okay, so 1227. The debtor cannot exempt himself from the performance of the obligation by paying the penalty, save in the case where his right has been expressly reserved for him. Neither can the creditor demand the fulfillment of the obligation and the satisfaction of the penalty at the same time, unless this right has been clearly granted to him. Okay, granted him. However, if after the creditor has decided to require the fulfillment of the obligation, the performance thereof should become impossible without his fault, the penalty may be enforced. Okay, so mukhang very straightforward naman ito. Hindi ibig sabihin na may penalty, magkakaroon na ng right si debtor na hindi mag-comply sa kanyang obligation. Okay? Pero hindi rin ibig sabihin na merong right si creditor to demand the fulfillment of the obligation and the penalty is ibig sabihin pwede niya itong i-demand at the same time. Okay? Hindi pwede. Parang isa-isa lang muna. So, i-demand niya muna yung fulfillment of the obligation. Hindi nag-comply. So, may penalty. I-demand mo ang pagbabayad ng penalty kung hindi niya pa rin talaga magawa yung obligation. So, ayun. Okay? Kung hindi niya magawa yung tawag dito, kung hindi na magawa totally yung fulfillment no, of the obligation, the penalty may be enforced. Okay? So, ayan. Pero hindi ibig sabihin, for example, kasi ganito, di ba? Meron kang utang, 1 million. Tapos, pag hindi ka na magbayad sa tamang oras, may penalty, let's say, na 1%. For example lang, di ba? Hindi ibig sabihin na kapag binayaran mo na yung 1%, hindi mo na kailangan bayaran yung 1 million. Hindi ganun yun, okay? So, kailangan mo pa rin bayaran yun, actually. Okay? Pero, syempre, hindi pwedeng sabay-sabay na enforce yun sa'yo. Syempre, hirap ka na magbayad. Tapos may penalty pa ulit. So, problema yun, okay? So, ayan. Article 1228, the proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. Okay. So, kung maalala nyo nung chapter 2, nature and effects of obligations, nandun yung mga different types of damages natin. Kung maalala nyo, itong penalty ay isang example ng liquidated damages. At kung maalala nyo, among the different types of damages, only the actual damages ang kailangan lang ng proof of pecuniary loss. Okay? Ang liquidated damages, hindi po kailangan ng proof of pecuniary loss. Okay? So, yun. Hindi kailangan. Okay? As long as merong provision yung kontrata nyo na may ganitong penalty, okay, pwede mo singilin yung penalty na yun in case of non-compliance. Okay? So, it doesn't matter kung meron kang na-incur na loss or what dun sa hindi niya pagbabayad. Okay? Pero, generally, meron ka may incur na loss. Okay? So, next, Article 1229. The judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Okay? Kung may nagawa naman siyang konti or partial dun sa principal obligation, o pwedeng babaan yung penalty. Yung judge, the court. Even if there has been no performance. Okay? Kapag walang performance, the penalty may also be reduced by the court if it is iniquitous or unconscionable. Yun yung for example, yung mga nagle-lending, yung mga lending company na grabe kung makapataw ng penalty kung sakaling hindi mo mabayaran, di ba? So, grabe yung penalty. So, pwede mong pababaan yan sa korte kapag pumunta ka doon. Kasi may mga, akalain mo yung babayaran mong penalty, mas mataas pa kaysa dun sa babayaran mong principal loan, di ba? So, very unconscionable naman na yun. Okay? So, 1230. The nullity of the penal clause does not carry with it that of the principal obligation. However, the nullity of the principal obligation carries with it that of the penalty clause. Okay? So, tingnan natin. Example. Y is a tenant of X. In their lease contract, there is a stipulation where should Y fail to pay 2 consecutive monthly payments, she will agree to become ex-mistress. Okay? So, alin dito yung obligation? The obligation is, syempre, yung to pay rent in their lease contract. And the penalty clause is the agree to become ex-mistress. Okay? So, the principal obligation is valid. However, the penalty clause is invalid by reason of being contrary to morals. Tama? Okay. So, therefore, ang invalid lang dito yung penalty. Okay? Pero valid pa rin yung obligation. Okay? So, yun. Sabi dito, the nullity of the penalty clause does not carry with it that of the principal obligation. Okay? Pero baliktarin natin. Y agreed to become ex-mistress. If ever, so may nakalimutan tayo. If ever Y wanted to back out from their agreement, Y must pay a penalty of 10,000. Yung penalty to pay 10,000 is valid on its own, di ba? Valid on its own. However, this penalty clause is based on an obligation that is invalid or, di ba? Kasi by reason of contrary to morals. So therefore, kahit na valid itong penalty clause dito, ma-invalidate na rin siya kasi yung obligation where it depends upon is invalid. So, pag binalikan natin yun, the nullity of the principal obligation carries with it that of the penalty clause. Okay? So, yun. Okay? Okay, so this is the end of the kinds of obligation. So, this is the end of the part 3. Okay, therefore, pupunta na tayo sa susunod na chapter which is Extinguishment of Obligation at mukhang mas hahaba pa ulit ang chapter 4 dahil medyo mas mahirap siya. Okay, Extinguishment of Obligation. Last time, nabanggit natin na merong mga different modes of extinguishment of obligation. Pero for the sake na hindi masyadong humaba yung mga videos natin and para at syempre para ma-release natin pa unti-unti yung chapter na ito, hinati po natin siya into 3 parts. So, first part, which is this video, will be based on the articles 1232 to 1251. Mag-focus muna tayo to the largest mode of extinguishment of obligation, which is payment or performance. Okay? And then, pagdating natin sa part 2, pupunta naman tayo sa mga different special modes of payment. Kumbaga, yung sa part 1, yan pa lang yung mga yung payment or performance in general. So, actually, maraming kwento yan. So, abangan na lang natin in this video. Part 2, so aside from the special modes of payment, we also have the loss of the thing, condonation, and confusion. So, some of the smaller subtopics under the extinguishment of obligation. And pagdating naman ng part 3, we will discuss compensation and novation. One of the the next two big topics in the extinguishment of obligation. And sometimes, yung compensation and novation, yan yung usually the hardest. Okay, hardest when it comes to extinguishment of obligation. Okay, pero huwag kayong maglala, i-explain natin yung mabuti. Okay, so let's start. Okay, ito yung Article 1231 para recall lang, okay, doon sa intro natin last time. So meron tayong 6, pero wag nyo rin kalimutan na may mga other ways pa para ma-extinguish ang isang obligation, pero hindi na po yun covered ng ating chapter na ito. Okay? So ayan. So starting with after yung 1231, starting with, so we have Article 1232, which is the first or initial article on the payment or performance section natin. Okay, so payment means not only the delivery of money but also the performance in any manner or in any other manner of an obligation. So when we say payment or performance, we refer to the fulfillment of obligations to give, which includes, okay, obligation to give includes the the obligation to give a specific thing and also the obligation to give a generic thing. And under the obligation to give a generic thing, nandyan po yung payment of money. And also, nandyan din yung performance, so obligation to do naman yun. Okay? So next. Yung payment or performance natin, hinati natin siya into 6, okay, subtopics. So number 1, okay, parang kumbaga tinitlean natin yung mga different subtopics na to into question. So, in this mode of extinguishment of obligation, number 1 question, who can pay? Sino ang pwedeng magbayad, okay, para ma-extinguish ang isang obligation? Obviously, siguro may sagot naman tayo dyan. Malamang yung kung sino yung may utang, di ba? Or kung sino yung obliged gumawa ng isang bagay, di ba? Okay? Ganun din sa number 2, who to pay? Sino ang babayaran mo? Malamang yung creditor, di ba? Ganun lang kasimple yun. Pero, syempre, marami pang kwento yan. Okay? Pagdating natin dyan, dyan nyo marirealize na hindi lang pala si debtor or hindi lang pala si creditor ang pwedeng magbayad or pwedeng tumanggap ng bayad. Okay? And next, Next, number 3, what to pay. So, may mga different rules tayo kasi regarding payment or performance. Depende kung anong klaseng obligation siya or kung ano yung babayaran. May rule tayo kapag ang babayaran ay isang specific thing. May rule din tayo kapag ang babayaran or kapag ang obligation ay isang specific thing or kapag ang obligation ay isang generic thing or magbabayad tayo ng pera or isa siyang obligation to do or not to do, okay? So, yun yung mga itatakal natin dyan sa number 3. Okay, number 4, how to pay naman, paano natin siya babayaran, okay? Itong number 4, para ma-spoil na kayo kung anong nilalaman itong number 4, basically, ang nagre-revolve yung concept natin dyan na dapat ang payment ay kumpleto. Okay, pero mamaya explain natin siya in detail. Number 5, saan tayo magbabayad? Para ma-spoil na rin kayo ulit, syempre, kung may napag-usapan yung parties, doon magbabayad, okay? Pero ano yung mga rules kapag walang napag-usapan? So, diyan natin itatakal. And lastly, when to pay, obviously, kung nag-mature na yung debt or kung kailan na siya, kailan ka na oblige, okay? Oblige bayaran yung isang bagay or gawin yung isang bagay, okay? Actually, diyan sa number 6, mag-a-apply yung, napag-aralan natin nung, what do you call this? The nature and obligations and contracts on the topic of demand and delay, okay? So, that is number 6, okay? So, umpisa natin from number 1, who can pay, okay? Who can pay? So, before we move on dun sa, presentation, nais ko lamang pong isa-isahin yung mga articles na involved dito sa first subsection natin, which is who can pay. Okay, dito sa who can pay, titignan muna natin yung mga related articles. So, ayan. First related article is 1236. So, this time hindi po tayo magdi-discuss chronologically ng article. Ibe-base po natin siya dito sa 1, 2, 3, 4, 5, 6 na questions na ito, and then hihila-hilain lang natin yung mga related articles, okay? So, Article 1236, yun yung first, the first related article to number 1, who can pay. So, the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor that he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. So, maya explain po natin yan. For now, babasahin mo lang muna natin. Next na related article is Article 1238. So, payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Okay? So, ayan. Meron tayo. Who can pay? So, generally, ang pwedeng magbayad ng malamang-lamang is the debtor himself, his authorized agent, kung meron siyang itinalaga na agent or mag-a-act on his behalf. And number 3, the successor in interest. Usually, nagte-take effect yung successor in interest kapag namatay. Okay? Usually, yung mga successor in interest, yun yung magmamana ng specific property na yun. So, for example, si debtor natin namatay, so meron siyang, let's say utang. Yes, tama. May utang siya sa isang specific creditor. And then, meron siyang mga anak, let's say, tas yung mga anak niya yun, may mamanahin, okay? So, part ng mamanahin nila, syempre, mamanahin din nila yung utang. Pero, syempre, in no case na lumampas doon sa mamanahin nila. Okay? So, yun ang mangyayari doon, okay? Pero, wag na tayong mag-dig into details doon, okay? Basta, ito yung mga tatlong, okay, generally, pwedeng magbayad, okay? At kung sila ang nagbayad, okay, yung payment natin ay valid. Okay? So, ito ang tatandaan nyo. Kapag valid ang payment, okay, kapag ang valid ang payment, tatandaan nyo, hindi po pwedeng tumanggi ang creditor. Okay? Hindi po pwedeng tumanggi ang creditor na tanggapin ito. Okay? So, ibig sabihin, kapag hindi niya kasi tinanggap yun, and valid yung payment, ang mangyayari is magkakaroon ng delay on the part of the creditor. So, magkakaroon tayo ng tinatawag na mora accipiendi. Okay? So, tatandaan nyo yun. Next, pwede bang magbayad ng third person? Of course, yes, nandito nakasulat. So, third person. Pero may mga certain scenario tayo dyan. Okay? Yung third person ba na nagbabayad ay interested in the fulfillment of the obligation? Or is the third person paying the debt is not interested in the fulfillment of the obligation? And lastly, is the third person third person paying the obligation do not or does not intend to be reimbursed, or kumbaga babayaran niya yung utang ni ganito pero hindi na siya magpapabayad sa specific debtor na yon. Okay, so may mga certain rules itong mga different scenarios na ito at i-illustrate natin siya sa mga upcoming slides. Okay, so umpisahan muna natin dun sa first scenario, which is yung third person na nagbayad ay isang interested person in the fulfillment of the obligation. Okay, so who can pay? Interested in the fulfillment of the obligation. So what are the key points sa scenario na ito? There will be valid payment. Okay, there will be valid payment. Okay, tatandaan nyo, kapag ang nagbayad ay isang interested person, pareha rin lang yung rule dito. Okay, yung sa tatlong ito. Ano yung rule dito sa tatlong to? Kung maalala nyo, baka nakalimutan nyo kaagad. Ang rule natin dito is, kapag itong tatlong nagbayad, okay, meron tayong valid payment. At hindi pwedeng tanggihan nung creditor na i-accept yung payment. Kasi kung sakaling tinanggihan man niya, magiging in delay na yung creditor natin. Magkakaroon tayo ng mora accipienti. Tama? Okay, so ganun din sa mga third person that is interested in the fulfillment of the obligation. Hindi pwedeng tanggihan ng creditor yung kanilang bayad. Okay? So in this case, as an example, D is indebted to C for 1 million. As a security, D pledged his car. Okay? So furthermore, G guaranteed the debt. Before the debt matures, G presented payment of 1 million to C. Okay, so bago natin i-analyze yung situation, sir, sabi ng interested in the fulfillment of the obligation, pero sino ba yung mga interested person na yan? Okay, paano kung yung boyfriend ko interested na ma-fulfill yung obligation ko? So, pasok pa siya sa definition ng isang interested person? The answer is no. Okay, so ito yung mga interested person usually. Okay, who are interested person? Usually, they are the guarantors, which is yun yung example natin in this case. So, G is a guarantor. Pwede ring mga sureties. So, yung mga sureties kasi parang guarantors din yan. Pero hindi natin siya i-discuss din within this topic kasi mapag-aaralan nyo yan in other laws. Okay? So, preferred creditors. Okay? Pag sinabi nating preferred creditors, sila yung mga creditor na dapat mo munang bayaran bago bayaran yung ibang creditors. Okay? So, kapag ang nagbayad ng isang utang, isang preferred creditor, isa siyang interested person. And usually, ito rin, pwedeng mangyari to, owners of securities. So, actually, merong security itong, itong example natin ito. Ano yung security ito? Actually, dalawang security, syempre. Yung guarantee, tapos yung pagpa-pledge. Okay? Pero, focus tayo sa pledge. Itong pledge, okay, yung pinledge ni D, nagkataon, and it's usually or generally the case, okay, na ang pinipledge mo ay yung mismong pagmamayari mo din. Okay, pero may chance or may instance na pwedeng i-pledge ang pagmamamayari ng iba. For example, pinledge mo yung pagmamayari ng kaibigan mo, syempre with his consent, tatandaan mo yun, okay? So, pinledge mo yung kotse niya, okay? So, kapag binayaran nung may-ari nung kotse na yon, yung utang mo, he is considered to be an interested person. Okay? So, next. So, ngayong alam na natin kung sino yung mga pwedeng maging interested person. So, siguro wala nang babagabag sa isip natin. So, proceed na tayo. Okay. Proceed na tayo dun sa pag-a-analyze ng ating situation. So, i-analyze natin yung mga key points. So, there will be valid payment. Okay? So, therefore, in this case, before the debt matures, G presented payment of 1 million to C. So, in this case, si C, which is the creditor, hindi po niya pwedeng tanggihan ang payment from G. Okay? Next, so, first bullet point natin, the creditor cannot refuse payment. Yun. Okay? Next, the debtor shall fully reimburse the third person. Okay? So, ang mangyayari is, ngayong nabayaran na ni G, Okay, si G, binayaran niya si C. So, sino na ang bagong creditor ni, ni D? Malamang-lamang si G na. Okay? So, meron ng obligation si D this time, okay? Nagkaroon na ng extinguishment ng obligation niya kay C kasi nagkaroon na ng valid payment, okay? Pero nagkaroon ulit ng bagong obligation si D, which is obligation niya kay G. Okay, so this is bullet point number 2. The debtor shall fully reimburse the third person. Okay? Pag sinabi nating fully, lahat. Okay? Kung ano yung binayad, kung magkano yung binayad ni G nung interested person, lahat yun i-reimburse niya. Regardless kung mamaya meron tayong another example, okay? Regardless kung naging beneficial ba yun sa kanya or hindi, okay? So, yun. I-illustrate natin yung sinabi ko yun, yung beneficial whatsoever, okay? Next bullet point, the third person is subrogated to the rights of the creditor. So, aside from the right acquired by G, which is to collect 1 million from D, the original debtor, masusubrogate din siya to the other rights of C. Ano ba yung mga other rights ni C in this case? Okay? The first right is to foreclose the pledge on the car. Okay? The second right is to go against G. Pero, syempre, nagkataon si G yung mismong nagbayad. So, syempre, mawawala na tong contract of guarantee na ito. Okay? So, yung masusubrogate niya sa kanya na rights is yung to foreclose the pledge on this car. So, if ever si G hindi makasingil kay D, si D hindi makabayad, wala na siyang, let's say, cash. So, ang mangyayari, pwedeng i-foreclose ni G yung pledge dun sa car ni D. Okay? Bilang, at yung magiging proceeds nung foreclosure, nung pledge, will be applied to the debt of D to G. Okay? So, yun yung magiging situation natin dyan. So, yun yung mga tatlong key points natin in this first scenario, which is kapag ang nagbayad isang third person which is interested in the fulfillment of the obligation. Okay? So, next. Okay? Next, let's go to the second scenario. Pero, again, before going to the second scenario, let's analyze or let's read the related article. So, Article 1237, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage guarantee or penalty. Okay? So, ayan. Additional provision ng Civil Code which applies to this second scenario. Okay? This second scenario is, ito yung not interested person yung nagbayad. So, dito na pasok yung tanong nyo kanina, what if yung scenario natin is yung boyfriend mo ang nagbayad ng utang mo. So, dito na siya pasok. Isa siyang third person not interested in the fulfillment of the obligation. Okay, so what are the key points? Okay? First key point, unlike doon sa una, this time, the creditor may validly refuse payment from a third person who is not interested in the fulfillment of the obligation. Yung kanina kasi, pag interested, hindi niya pwedeng may refuse. Okay? Pero this time, pwede niyang ma-refuse. And kung i-refuse niya man, hindi siya in delay. Okay? Kasi valid yung magiging refusal niya. Okay? Kasi hindi naman interested person yung nagbabayad. Okay ba? Okay. Pero what if, nevertheless, tinanggap ni creditor. So, ito yung mga susunod na key points natin. Okay. If the debtor consent to the payment, so dalawa yung magiging parang scenario natin dito. Okay? Titignan natin yung consent ni debtor. If the debtor consent to payment or if the debtor does not consent to the payment. So, unahin muna natin yung una. If the debtor consent to the payment, ang magiging rule po natin dyan ay just like the previous scenario, which is the debtor shall fully reimburse that third person and the third person is subrogated to the rights of the creditor. Okay? So, for yung kanina, which is actually, ganun pa rin yung natin, pero this time, naiba na yung nagbayad. Okay? So, basahin natin tong example natin. D is indebted to C for 1 million. As security, D pledged his car. Ganun pa rin yung natin. 2 months before the debt matures, okay, dito na magkaroon ng pagkakaiba. So, D paid 100,000 to C which the latter accepted. Okay, sinong nagbayad muna? Okay, so nagpauna si D. In this case pala, nagpauna muna. Nagpauna muna siya ng 100,000 pesos to see which the latter accepted, which is completely okay kasi nagkasundo naman si D and C. Okay? So, in this case, up to this point, ilan na lang ang utang ni D? Ilan na lang ang utang? Oh, minus lang. 1 million minus 100,000. So, 900,000 na lang ang utang ni D. Tama. Okay. So, next. 1 month before the debt matures, okay, so after 1 month, nung nagbayad siya ng 100,000, X, which is a third person not interested in the fulfillment of the obligation, presented payment of 1 million to C. Okay? So, pag not interested, by the way, kung hindi siya pasok doon sa mga nilist down natin na mga interested person, ibig sabihin, hindi siya interested in the fulfillment of the obligation. Ganun lang po yun kasimple. Okay? So, X presented payment of 1 million to C. So, inuulit natin. Balik tayo dun sa first key point. Pwedeng tanggihan to ni C at this moment. Okay? Pero, nevertheless, assuming tinanggap niya. Okay. So, dito na. Kung tinanggap niya, dalawa yung magiging parang kumbaga, dalawang scenario after that, okay? So, it's either the debtor consent or the debtor does not consent, okay? So, first scenario muna tayo, the debtor does consent. So, in this case, magkano ang pwedeng singilin, okay? Magkano ang pwedeng singilin, okay? Magkano ang pwedeng singilin ni, sino na yun? Si X, ng third person from the debtor. Kasi, effectively, si X na ang bagong creditor this time kasi tinanggap ni C. Okay, so, okay. So, magkano ang pwedeng singilin ni X from D kapag si debtor ay nag-consent? Okay? So, obviously, nandito tayo. Okay? The debtor shall fully reimburse the third person. Okay? Dahil si X nagbayad ng 1 million, itong loko-lokong C, tinanggap niya yung buong 1 million. Oh, bakit? Ano bang mali doon? Actually, mali yun kasi dapat sinabihan ni si X na 900,000 na lang yung utang ni D, di ba? Kasi nagbayad na si D ng 100,000, nagpauna na siya. Okay, pero in this case, tinanggap niya pa rin, okay? Pero ang tanong, magkano ang pwedeng singilin ni X mula kay D? Ang sagot ay 1 million pa rin kasi nag-consent naman si D. Okay? So, ang mangyayari, dahil pwede niyang singilin yung buong 1 million kay D, okay, si D, malulugi ng 100,000. Okay? So, kanino niya pwedeng kolektahin yun? From C. Okay? From C. Kasi si C yung na benefit ng 100,000. Okay? So, pwede niyang kolektahin kay C. Okay? Pero, with regards to X and D lang, okay, pwedeng singilin ni X yung buong 1 million. Kasi, nag-consent si debtor dun sa, what do you call this? Dun sa payment. Di ba? Ni X papunta kay C. Okay? So, ayun. The third person will also be subrogated. So, ayan. The third person is subrogated to the rights of the creditor. So, ang mangyayari dito, if ever si D hindi makapagbayad kay X kasi wala na siyang cash, pwedeng i-foreclose ni X yung pledge doon sa car. Okay? So, yun lang yung tatandyan nyo yan. Okay? So, next scenario tayo. If the debtor does not consent, paano kung hindi siya nag-consent? Ganun, actually, magkakaroon pa rin ng valid payment. Okay? Magkakaroon pa rin ng valid payment dito si X papunta kay C kasi it doesn't matter kung nag-consent si debtor or hindi. As long as okay, si creditor, hindi niya ni-refuse yung payment, okay lang. So, nagkaroon pa rin ng valid payment from X to C. However, meron tayong dalawang rules dito. 2 bullet points, yung dalawang last na bullet points natin dito. So, basahin natin. The debtor shall reimburse the third person for what has been beneficial to him. So, in this case, okay, hindi nag-consent si D. So, si X maniningil na ng 1 million. Pwede niya bang singilin yung buong 1 million? Actually, hindi. Kasi, ang pwede niya masingil ay up to the extent na na-benefit si D. Hanggang magkano lang ba na-benefit si D doon sa pagbabayad ni X ng 1 million? Hanggang 900,000 lang. Kasi 900,000 na lang yung utang niya. Okay, ganun lang kasimple yun. So, kapag tinanong kayo, magkano ang pwedeng singilin ni X mula kay D? At this point, dahil hindi naman nag-consent si D dun sa payment ni X kay C, ang mangyari is, masisingil niya lang is up to the extent na naging beneficial yun kay debtor. Okay? So, last key point. The third person is not subrogated on the rights of the creditor. So, simple lang, ganun, if ever si X, okay, if ever si X maniningil na kay D at hindi siya makasingil kasi wala ng cash si D, in this case, hindi na siya, kumbaga hindi niya na magiging option ito, yung pledge, yung foreclosure ng the pledge object, di ba? So, wala na. Hindi niya na pwedeng ma-foreclose yung pledge car. Okay? Kasi hindi na siya masusubrogate dun sa other rights. So, yung right niya lang is to collect from D. Okay? So, yun ang pagkakaiba nung dalawang sub-scenario dito within this scenario, di ba? Okay? Which is yung if the debtor consent to the payment or the debtor does not consent to the payment. So, this is nabanggit dun sa Article 1231 na binasa natin kanina. Okay? And punta na tayo sa huling scenario, which is the third person who paid the creditor does not intend to be reimbursed, or hindi niya, parang kumbaga binayaran niya, di ba? Good Samaritan, binayaran niya kahit hindi mo na ako bayaran. Ang objective ko lang naman maging happy ka, di ba? Maging happy ka na mawawala na yung utang mo, okay? So yun ang nangyari. Okay? So in this case, may may medyo almost the same pa rin yung scenario from the previous one, pero again, syempre magkakaroon ng pagkakaiba yan. Kasi bakit pa natin siya ihiwalay na scenario kung totally walang pagkakaiba, okay? So number 1, okay, first key point, just like the second scenario, the creditor may validly refuse the payment, okay? Pero kapag in-accept niya, okay, so doon na tayo, doon natutuloy. Okay, doon natutuloy itong mga next scenario na ito, okay? So next bullet point, if the debtor consent to the payment, it is deemed to be a donation. Okay. Kasi after i-accept kasi ng creditor, diyan nasusunod yung say ni debtor. Okay? So titingnan natin yung say ni debtor. Debtor, magko-consent ko ba? Okay lang ba sa iyo na ganun, di ba? Yung babayaran niyo yung utang mo, tapos kahit hindi mo na daw siya bayaran, okay? So, syempre, sino ba naman ang debtor na ayaw nun, mawawalan ka na ng utang. Okay, so yun ang mangyayari, okay? So kapag inaccept ni debtor, okay, consent to the payment, the transaction will be deemed a donation on the debtor and the third person's part, di ba? Okay, pero on the part of the debtor and the creditor, syempre nagkaroon na ng na-extinguish na yung obligation ni debtor kasi binayaran na siya ni nung third person na yon, okay? Okay, pero okay, syempre, ito, although hindi practical, pero syempre, may chance na pwedeng mangyari pa rin. Paano kung hate na hate mo yung, yung taong yun, yung nagbayad sa'yo? Okay, binayaran ka ng utang, pero hindi, ma-pride ka, ayaw ko. Hindi kita gustong magbayad ng utang ko. Okay, so, if the debtor does not consent to payment. So first, the debtor shall reimburse the third person for what has been beneficial to him. So parang ganun din lang sa second scenario. Okay? At ganun din sa second bullet point. Actually, magkapares lang yan. The third person is not subrogated to the rights of the creditor. So saan lang siya nagkaiba? Dito lang. Sa second bullet point, which is yung second scenario, magkakaroon ng reimbursement for the full amount and subrogation. Pero dito sa third scenario, it will be deemed to be a donation. Okay? So bakit pala ganun? It will be deemed to be a donation. Okay? So okay naman, okay siya maging donation kasi actually pag nag-consent si debtor, okay na yung yung parang kumbaga general requisite ng donation, which is kailangan kasi pag nagkakaroon ng contract of donation, kailangan ng consent nung donee. Okay? Pero depende yan kung ano yung i-donate mo. May mga instances na kailangan pa ng public instrument whatsoever. Okay? Pero itatakal natin yan in detail pagdating natin sa contracts. Okay? So, ayan. So, ito yung hindi na natin nabasa tuloy yung example. So, D is indebted to C for 1 million as security. Actually, paras pa rin. D pledged his car 2 months before the debt matures. D paid 100,000 to C, which the latter accepted. So, 1 month before the debt matures, X presented payment of 1 million to C. Ang pagkakaiba nito, although copy-paste lang to from the second scenario, ang pagkakaiba, si X, he does not intend to be reimbursed. Okay? So, yun ang pagkakaiba. So, in this case, kapag nag-consent si debtor, ayun nga. Okay? Bayad na yung utang niya kay C, wala nang extinguish na yung obligation natin. At the same time, magkakaroon na ng contract of donation din. Okay? Pero what if the debtor does not consent? So, In this case, ang mangyayari is, X will be the new debtor, or I mean, the creditor of the debtor of D. Di ba? Pero, kapag maniningil na si X from D, magkano lang ang pwedeng masingil niya? Okay? 900,000. Kasi, ganun din sa second scenario, wherein if the debtor does not consent to the payment, the debtor shall reimburse third person for what has been beneficial to him. So, ang naging beneficial lang in this case is 900,000 kasi nagpauna na siya ng 100,000. Okay? So, ayun. Ganun din sa last bullet point natin, the third person is not subrogated. So, kapag si X, okay? Kapag si X hindi makasingil kay D for the 1 million na utang, okay? Hindi niya pwedeng i-foreclose yung pledge dun sa car. Okay? So, let's go to the... Okay, so ayan, summary lang. Interested in the fulfillment of the obligation, not interested in the fulfillment of the obligation, does not intend to reimburse. Yan yung mga summary of key points natin. Okay? So, next, punta na tayo sa who to pay. Sino ang babayaran? Okay? So, under Article 1240, okay, ayan. The debtor, obviously the debtor, the authorized agent, and the successor in interest. Okay, so mukhang na-copy-paste natin yung kanina. Who can pay. Okay. Ay, na-copy-paste ata natin. Kasi who to pay nakalayo ngayon eh. So, na-copy-paste natin yung kanina. Okay, who to pay, syempre ang babayaran mo si creditor. Okay, creditor. Okay, na ano ba yan? Palpak na naman ang PowerPoint natin ngayon. Okay, so creditor, or pwede mong bayaran yung kanyang authorized agent or his successor in interest kapag in case na namatay si creditor, di ba? So, yun ang pagbabayaran mo. Okay? So, ayan. Ganun din, dun sa rule natin, dun sa who will pay, di ba? Kapag ang pinagbayaran mo is si creditor mismo, or yung kanyang authorized agent, or yung kanyang successor in interest in case of namatay si creditor, there will be a valid payment. Okay? So, ayan, valid payment. Malaking dyan. Okay? Okay. Meron tayong box dito. What if? Okay? Itong mga to, incapacitated. Kasi may chance na nung nagkaroon ng obligation, na constitute yung obligation mo, matitino pa sila. Pero, di naglaon, nabaliw sila. Okay? Nung nabaliw sila, that's the time na gusto mo nang magbayad, pero yun nga, pwede mo bang bayaran ng isang baliw na creditor? So, ang general rule ay, kapag ginawa mo yun, invalid yung gagawin mong payment. Okay? So, inuulit ko, invalid yung gagawin mong payment, hindi yun nare-recognize as payment. Ibig sabihin, if ever, kapag yung baliw na yun, na creditor, nawala niya yung pera, tinapon niya, kinain niya, or whatsoever, di ba? Ang mangyayari is, may utang ka pa rin sa kanya, hindi pa na-extinguish yung obligation mo. Okay ba? Okay. Pero may mga certain exemptions pa rin to the rule. Okay? So, exemption number 1 is the incapacitated person kept the thing delivered in case of obligation to give. Diba? For example, ang obligation to give mo ay to give a specific cellphone. So, ayun, tinago niya yung specific cellphone sa bahay niya. Okay? Pero, baliw siya at the moment, Okay, take note, baliw siya. So, number 2 naman, if payment benefited him. So, for example, may utang ka sa kanya, pera. Let's say, 1,000 pesos. Pero, ang nangyari, yun nga, nung magbabayad ka na, baliw na si creditor. So, ayun. Pero, pinilit mo pa rin na ibayad. So, ang nangyari is, pinambili niya naman ng pagkain. Okay? Pinambili niya naman ng pagkain, pinambili niya ng bigas. So, pero, take note, baliw siya. Okay, at that moment, okay? Pero, yun nga, na-benefit siya nung payment. Okay, so, exception to the general rule yun. Okay? So, yung mga certain scenario kasi natin, yun nga, yung parang kumbaga para maging safe, syempre, na para ma-extinguish na lang yung obligation mo is, huwag mo siyang babayaran habang baliw pa siya. Okay? So, next, pwede bang magbayad sa third person? Okay? Pwede bang magbayad sa third person? So, this time, wala po tayong concept ng, ng interested person, not interested person. Okay? Basta third person lang. Okay? So, magiging valid ang payment sa isang third person if, okay, if the benefit redounded to the creditor. Ibig sabihin, ganito. Mamaya, may example tayo actually para mas maintindihan nyo kung ano yung redounded to the benefit, that benefit redounded to the creditor para mas maintindihan nyo kung ano yan. Okay? Ibig sabihin ganito, every time, okay, para maging safe, tatandaan mo na lang, para maging safe yung payment. Kapag magbabayad ka ng utang mo, siguraduhin mo na pinagbayaran mo mismo ng utang mo is yung mismong creditor or yung kanyang authorized agent. Okay? Hindi pwedeng third person, hindi pwedeng kapitbahay, hindi pwedeng kaibigan niya lang, napakibigay na lang, parang ganun. Kasi may chance na hindi ma-acknowledge yung payment mo at may chance na baka magbayad ka pa ulit kasi yun nga, hindi pa na-extinguish yung obligation mo. Okay, pero syempre, sa korte, syempre pwede mo na, may chance ka naman para patunayan yan. Okay? Magiging valid lang ang payment mo sa third person kapag ma-prove mo na yung benefit ay napunta kay creditor. Okay? Pero may mga exemptions dyan wherein hindi mo na kailangang patunayan that the benefit redounded to the creditor. Ito yung mga tatlong yun. After the payment, the third person acquires the creditor's rights. Ibig sabihin, siya na ang bagong creditor mo in this case actually. Okay? Or na-acquire niya yung, for example, pag may promissory note, binenta para sa kanya nung creditor mo yung promissory note. So, malamang siya na ang pagbabayaran mo yung third person na yun. Number 2, if the creditor ratifies the payment to the third person. Okay? Pag sinabing ni-ratify, so, binayaran mo third person. Binayaran mo kaibigan ng creditor, for example. Okay? So, binayaran mo si kaibigan niya, kasi hindi mo mahanap, let's say, si creditor. So, uy, pakibigay na nga lang to kay ganito, ganyan, okay? Pag nakita mo siya, kasi magka-office naman kayo, di ba? Parang gano'n, okay? So, ang mangyayari is, kapag sinabihan mo si creditor, sa wakas, na-contact mo na siya. Sa wakas, nag-reply na siya. Okay? So, nakausap mo si creditor, sabi mo sa kanya, creditor, binigay ko kay ganito yung utang ko. Okay, sige, kunin ko na lang sa kanya. Okay? So, at that moment, okay, ni-ratify niya yung payment mo dun sa third person na yun. Ibig sabihin, at that very moment na okay, sabi niya na okay lang pa, okay, so kukunin ko na lang sa kanya. At that very moment, extinguish na yung obligation mo. Okay? Kasi ni-ratify ni creditor. At hindi mo na kailangang i-prove na nag-redown yung benefit dun kay creditor. And lastly, number 3, if by the creditor's conduct, the debtor had been led to believe that the third person had authority to receive payment. Okay? So, ayun, parang kumbaga, through the actions of the creditor or conduct, ang nangyayari is, akala mo, pwede mong pagbayaran yung taong yun, di ba? Pwede mong sa kanya na lang ibigay yung bayad kasi pinamumukha niya sa'yo na yun yung authorized agent niya. Okay? Well, in fact, hindi pala. Okay? So, yun. Okay? Yun yung mga senaryo natin. Okay? So, next. Article 1240. So, payment shall be made to the person in whose favor the obligation has been constituted or his successor or interest or any person. So, nahuli siya. Okay, napakita muna natin yung yung ganito natin before the related article. Okay, so 1241, payment to a person who is incapacitated to administer his property shall be valid if he kept the thing delivered. So, ito, sinabi natin, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as he has redounded to the benefit of the creditor. Such benefit to the creditor need not be proven in the following cases. Okay, so ano nangyari? Napindot na naman natin yung N. Okay. Saan na tayo? Okay, dito na tayo, I believe. Okay, so ayan. Such benefit to the creditor need not be proved in the following cases. So ayan, 1, 2, 3, yan yung binanggit natin kanina, in-explain natin kanina. Okay, so ayan. Example. Okay, so dun pa rin tayo sa who to pay. Okay, so example, D is indebted to C for 100,000. On maturity date, C is insane. So ito yun, na example natin kanina. And despite being aware of the insanity, D still paid C 100,000. Okay, so ayan, yung mga rules na yan. Mag-a-apply yung mga rules na yan na nabanggit natin yan. Okay? So, ayan. Depende kung anong gagawin ni creditor dun sa bagay na yun. Kung tinapon niya yun, valid yung payment. Pero kung naging beneficial yun sa kanya kasi pinambili niya ng needs niya or ng pagkain niya or whatsoever, magiging valid yung payment at that time. Okay? So, next. So, ito, kinumpleto natin ulit. Okay, so this time, i-explain naman natin to. Actually, ganun pa rin. Okay, so D is indebted to C for 10,000. On maturity date, D went to C's house to pay. C was not in the house. Okay, so hindi niya makita. sayang naman ang pinagpunta niya kung wala siyang mapapala doon. So, ang nangyari, ginawa niya, D as X, which is the neighbor of C. Pero hindi authorized ni C to accept payment. Okay, to receive the 10,000 and give it later to C when C gets home. Okay, so ang tanong, is the payment by D to X, which is the neighbor of C, a valid payment? The answer is no. Okay, the answer is no. So, kapag nawala yun ni X, tandaan, invalid yung payment na ginawa niya. Kapag nawala ni X yung pera, hindi napunta kay C, may utang pa rin si D kay C. Okay? So, hindi pa ma-extinguish. Okay ba? Pero, okay, if si C, let's say, nakauwi na, okay, nakauwi na siya ng bahay, at yun nga, mabait naman yung kapitbahay, binigay ni X yung na-receive yung payment na 10,000 papunta kay C. Okay, so at that moment ang nabigay kay C, at that moment na nag-redown yung benefit kay creditor, okay, nagkaroon na ng valid payment. Pero, tandaan, ang burden of proof, syempre, nakay debtor pa rin. Nakay debtor pa rin ang burden of proof. Siya dapat ang magpatunay na talagang napunta kay creditor. Kasi may chance dito, or baka kasi si C magsinungaling. Wala naman binigay sa akin si X. So, may possibility na ganun. O, paano mo yung mapapatunayan? Okay? So, to be safe, pag magbabayad ka, kay C na lang mismo or sa kanyang authorized agent. Okay? So, next. Punta na tayo doon sa whom to pay. Ano na ba? Who can pay, whom to pay. So, ang susunod na ay what to pay. So, ayan. Mga related article, 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obliger's will. So, explain natin yan mamaya. So, ayan. Actually, i-explain natin ngayon kasi hindi ko alam kung may ano pa yan? Hindi, mamaya na. Okay, so, another related article is Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality, neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. And I believe this is the last, yes, this is the last article na related. So, Article 1249, the payment of debts in money, okay, so we are talking about money, shall be made in the currency stipulated. And if it's not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to order or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cash or through the fault of the creditor they may have been impaired. Okay? So, ayan. In the meantime, the action derived from original obligation shall be held abeyance. Okay? So, ayan. Na-explain natin kung ano yung mga yun. Okay, ayan, i-summarize natin into yung mga nabanggit or ng mga related articles na yun, okay? So, what is to be paid? Kapag ang babayaran ay isang specific thing, to give a specific thing, the debtor cannot compel the creditor to receive a different specific thing, even the latter has the same value or more valuable than that due. Okay? So, kapag napag-usapan niya isang specific dog, yung specific dog na yun, ang kailangan mong ibigay. Dahil kapag nagbigay ka ng ibang dog, hindi yun valid payment at hindi may extinguish ang yung obligation. Okay ba? So next, to give a generic thing naman tayo. So debtor cannot demand a thing of superior quality. The creditor cannot demand a thing of superior quality as well as the debtor cannot deliver a thing of inferior quality. So, ang ibig sabihin nito kapag for example, okay, ang ibibigay mo sa akin ay ballpen para gagamitin ko sa office, for example, ganun. And ang napag-usapan nyo ay let's say yung around ganitong price range, 50 pesos, parang ganun. So, si creditor, hindi siya pwede mag-demand ng sobrang taas sa 50 pesos, which is mga 1,000 na ballpen, ganun din si debtor, hindi siya pwede mag-deliver ng panda na ballpen kasi 50 pesos yun na pag-usapan, so ganun yun. Okay? So kapag ang ano nyo, ang quality na pag-usapan nyo is nandoon sa bandang 50 pesos, so yung around 50 pesos, okay, ang kailangang ma-deliver. Okay? Pero what if hindi nabanggit ang quality? Okay? So yung intention, okay, yung paggagamitan. So, dapat malinaw between the creditor and the debtor kung ano ba ang paggagamitin mo. Okay? So, meron kang obligation na, let's say, magbigay ng, martilyo. Ang paggagamitan niya ng martilyong yun, pampupukpuk niya ng bakal, di ba? Ang binili mo lang, ewan ko kung may mga ganong uri ng martilyo, hindi lang ako sure. Bigla ko lang naisip yung example na to, okay? So, yun, parang kumbaga, take into consideration natin yung kung saan niya gagamitin. So, ayan nga. Quality and circumstances have not been stated, so the purpose of the obligation and other circumstances shall be taken into consideration. Yun ang iti-take into consideration in the fulfillment of the obligation. Pero para maging safe, kailangan nating, okay, para maging safe, para walang lituhan, i-specify nyo na lang kung ano yung ibibigay niya, di ba? Para maganda, hindi walang pagtatalo. Okay, so that is from Article 1246. Next, obligation to do or not to do. So, in obligations to do or not to do, an act or forbearance cannot be substituted by another act. Okay? Or forbearance against the obliger's will. Okay, so for example, meron kang obligation to repair the laptop. Okay? So, yun yung obligation mo. Hindi mo pwedeng palitan. Hindi mo pwedeng, hindi na lang laptop ang ipapaayos ko sa'yo. Ang ipaayos ko na lang is yung cellphone. Okay? So, hindi pwede. Okay? Kasi ang napag-usapan yung laptop, tapos naging cellphone, di ba? So, hindi pwede. Okay? Ganon din sa obligation not to do. Kapag una nyo napag-usapan, paano ba yan? Huwag kang magpapatayo ng, paano ba yan? Okay? Meron kang inupahang lupa. Okay? So, yung lease agreement nyo, sabi niya, huwag kang magpapatayo anong tawag dito? Ng restaurant. Okay? Yun yung una. Okay? Pero, bigla niyang iniba. Gusto niyang ibahin. Ang gusto niyang gawin mo, hindi. Huwag kang magpatayo ng apartment, sabi niya. Okay? So, hindi pwede yun. Okay? Hindi pwede yun na biglang palitan, biglang mag-substitute ng other act, ng other forbearance. So, yun yung forbearance. Actually, yun yung meaning nun. Yung parang, kumbaga, yung, forbearance. Okay? Yung nililimit ka or huwag gagawin, parang ganun. Yun yung forbearance. Okay? So, yun. Kumbaga, yung act dito, it relates to obligations to do. Yung forbearance naman, it relates to obligation not to do. So, yun. Okay? So, importante na kapag nag-aaral kayo ng mga ganitong subjects such as law, kailangan meron kayong dictionary. Kaya kapag hindi kayo maintindihan na words such as this, pwedeng-pwede niyong puntahan. Okay? So, actually, hindi nyo kailangan dictionary. Sa cellphone nyo pa lang meron ng pwede nyo ma-search sa Google. Okay? So, last, obligation to give money. Okay? The payment of debt in money shall be made in the currency stipulated. So, kapag sabi ng obligation mo is magbayad ka ng 1 million, okay? 1 million pesos in dollar. Okay? Pero in dollar, yung ibibigay mo. 1 million pesos siya in dollar pero. Okay? So, yun ang susundan mo. Yun ang pambabayad mo, dapat yung dollar. Hindi pwedeng magbayad ka ng peso na currency. Okay? Pero kung hindi possible, kasi let's say hindi ko alam, basta let's say hindi possible. Okay? Kumbaga, let's say nangyari? Ganito na lang. Bumagsak ng ekonomiya ng US. Okay? So, nawalan ng value yung dollar. So, ano nangyayari doon? Okay, ang mangyayari is, syempre, meron ka pa ring obligation, pero hindi na kasi possible siya na i-deliver at that certain currency. So, ang magiging, delivery na lang is yung Philippine peso na lang. Okay? So, legal tender in the Philippines. Okay? So, ganun. Okay, so initially, inulit ko kung ano yung napag-usapan na currency, type of currency na pagde-deliveran ng pera. Yun yung pambabayad mo. Okay? Next, how to pay naman po. Okay, so, in-spoil ko na kayo kanina na dito sa how to pay. Okay, ulit. How to pay, ang pinaka parang kumbaga concept dito is yung payment must be complete. Ayun. General rule. In paying, payment must be complete. The creditor or the debtor cannot be compelled to accept or make partial payments. However, there are exemptions. Okay? First is when the creditor waives complete performance. So, mamaya explain natin yan. Pangalawa is if there is a contrary stipulation, what if yung pagbabayad pala ay via installment? Okay? And lastly, if the debt is partly liquidated only. So, malamang part lang din nung debt ang pwede mong mabayaran kasi part pa lang nung debt yung na-determine yung value, di ba? Yung amount. Okay? So, ayan. And another, we have a rule. What if there is a substantial performance in good faith? However, it is still not complete. Pero, in good faith. Okay? In good faith. Okay? So, mamaya explain natin yan. Okay. So, ayan. Ito yung mga related article. Article 1233. A debt shall not be understood to have been paid unless the thing or service of in which the obligation consists have been completely delivered or rendered. So, yun yung sinasabi natin sa first part. If the obligation has been substantially performed in good faith, okay, ito yung sinasabi natin. The obligor may recover as though there have been a strict and complete fulfillment, less damages suffered by the obligee. So, mamaya may example tayo dyan. Article 1235. When the obligee accepts the performance knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. So, isa yan sa mga exemptions natin. And next, 1248. Okay? So, unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestation in which the obligation consists. Neither may the debtor be required to make partial payment. So, applicable yan both on yung completeness na concept, applicable yan both on the part of the creditor and the debtor. However, when the debtor is in part liquidated and in part unliquidated, so isa yun ulit sa mga exemption natin, the creditor may demand the debtor may effect the payment of the former. Yung former, yung liquidated part. Yung liquidated part ang pwede niyang mabayaran. Without waiting for the liquidation of the latter, without waiting for the liquidation of the unliquidated part. Okay? So, ano ba yung liquidated? Yun nga, di ba may mga certain liabilities, hindi ko alam kung napag-aralan nyo na to, pero may mga certain liabilities na hindi pa liquidated. Ibig sabihin, hindi pa natin na-determine yung amount. Okay, such as mga provisions for liabilities natin, di ba? Hindi ko alam kung alam nyo yun. Or napuntahan nyo na yun na topic. Okay? So, yun nga, nag-ano tayo ng provision, hanggat hindi pa dumarating yung isang time, isang specific period of time na madedetermine talaga natin yung exact amount, okay? Considered pa siya na unliquidated, okay? Pero nagkakaroon tayo ng estimate. Okay? So, next, how to pay pa rin. Balik tayo dun sa how to pay. So, ayan. General rule. Okay. Ang pagkakaiba, nilagyan ko ng guhit. Okay? So, substantial performance, debtor may recover as if there has been a complete. Okay, so, gawa muna tayo ng example. Okay, so, example. Dun sa general rule and the exemptions. Okay? D is indebted to C for 90,000. On maturity date, D cannot compel. Tama, okay? On maturity date, D cannot compel C to accept 80,000 only for now. Okay? Nor is C to compel D to pay 60,000 only for now. So, for example, nagbabayad si D, ito muna ang kaya kong ibayad, 80,000, saka mo na yung 10,000. Okay? Pwede ba yun? Pwede niya bang i-compel si C na i-accept yung 80,000? The answer is no. Pwedeng tanggihan ni C. Hindi. Sabay-sabay mo na lang bayaran. Magbabayad ka na rin ng interest for the whole amount. So, pwede yun. Pwede niya sabihin yun. Ganon din sa part ni C. Hindi pwedeng sabihin ni C na, for example, ready nang magbayad si D for the total amount of 90,000. Ready na siya magbayad ng 90,000, pero sabi ni C, pwede bang ibulsa mo muna yung 30,000, 60,000 lang muna, baka kasi mawala ako. Diba? Hindi pwede. Okay? Hindi pwede. Hindi niya pwedeng i-compel si D na ganun ang maging situation natin. Okay? So, next. Okay, example naman natin yung substantial performance in good faith, kung anong ibig sabihin yan, okay? So, ito yung example natin. D is bound to deliver 10 sacks of rice to C due to a certain circumstance beyond the control of D. So, wala sa control ni D. D is only able to deliver 9 sacks of rice. In this case, assuming each sack cost 2,000, C is bound to pay 18,000, which is 2,000 times 9 sacks, less damages suffered by C. So, ano yung damages suffered by C? O, hindi ko alam kung ano yung masasuffer niyang damages. Okay, basta kung may nasuffer man siyang damages, ima-minus yun sa 18,000, which is supposedly babayaran niya kay D. Kasi basically, this is a sale, di ba? Sale of the sacks of rice. So, ayan. Yung 18,000, magkakaroon siya ng discount kasi, di ba, naging ano sa kanya yun, naging ano sa kanyang part, naging inconvenient sa kanyang part kasi kailangan niya 10 pero 9 lang na deliver. Okay? So, malamang may chance na mag-suffer talaga siya ng damages. Okay? So, ayan. Magiging valid yung payment insofar as doon sa kaya niyang ma-perform, which is in this case up to 9 sacks only. Okay? So, yun. 9 sacks times 2,000 each less damages. Yun yung babayaran ni C. Okay? Okay. Next, we have, okay, so nabanggit na natin yung ano, who can pay, who to pay, what to pay, and how to pay. So, pupunta na tayo sa where to pay. So, under Article 1251, payment shall be made in the place designated in the obligation. There being no express stipulation, if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation is constituted. In any other case, the place of payment shall be the domicile of the debtor. So, malinaw. Okay, if the debtor changes his domicile in bad faith or he has incurred in delay, the additional expenses shall be borne by him. Okay? This provision, okay, blah, blah, blah. So, huwag na natin masyadong ano yun. Okay, so, kung saan mababayad, syempre, ang general rule yung stipulation, kung ano yung napag-usapan nila. Pero, what if there's no stipulation? So, may dalawang cases tayo. If ang obligation ay obligation to give a specific thing, ang pagbabayaran ay kung nasaan man yung specific thing. Kung kailan na-constitute yung obligation. Kung kailan napag-usapan yung obligation. Okay, constituted hindi currently kung nasaan. Okay, kung kailan na-constitute yung obligation. Okay, tatandaan nyo yan. Another scenario is yung kapag ito naman ay any other type of obligation aside from obligation to give a specific thing. So, diyan nagfo-fall yung mga obligation to do, obligation not to do, obligation to give a generic thing. Okay? So, that will be at the domicile or kung saan yung lugar. Okay? Place ni debtor. Okay? The domicile of the debtor. Okay? So, ayan. Yun yung where to pay. How about when to pay? So, syempre, upon demand. Okay? Usually, yung demand na yan, nangyayari, syempre, on due date. Diba? Kung kailan nag-due na yung obligation. Hindi ka naman pwedeng magkaroon ng valid demand if the debt is not yet due. Okay? But the debtor may pay before due date if period is for the benefit of the debtor. So, yung benefit of the debtor, only, for the benefit of the debtor only. Yan yung kapag ang stipulation natin is, the debtor can pay on or before the due date. Malamang pwede siya magbayad before the due date. Okay? So, yun yung benefit of the debtor only, yung period. Okay? So, ayan. Okay. Ito naman, yung mga susunod na article, ito naman yung mga article na hindi pasok doon sa mga certain, yung mga nabanggit natin, yung when, where, what, how, who, etc. Okay, so yun. Ito na yung mga hindi pasok. So, explain natin itong mga, para wala tayong ma-miss out na article. So, umpisa natin sa Article 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid without prejudice to the provisions of Article 1427. So, wala tayong example. So, meron tayong example pala. Okay? So, ito, D is bound to deliver to C a dog. On due date, D delivered a dog. He stole from a pet shop to C. So, in this case, okay, pwedeng validly, okay, inulit ko, pwedeng validly hindi i-accept, okay, ni creditor yung payment ni D kasi ang binibigay niya isang specific dog. I mean, hindi isang specific, ay isang dog na ninakaw or wala siyang free disposal, di ba? Kasi ang nangyari dito, nakalagay dito, shall have the free disposal dapat. Okay, in obligation to give. Payment made by the one who does not have free disposal shall not be valid. Okay? So, pwede mong tanggihan tong payment na to. Okay? Kasi hindi valid payment yung ginagawa niya. Okay ba? So, ganun lang kasimple yung Article 1239. Next, we have Article 1242. So, what is Article 1242? Payment made in good faith to any person in possession of the credit shall release the debtor. Okay? So, as an example, mag-example tayo. I believe mayroon tayong example dito. So, meron nga. Okay. So, D is indebted to C for 100,000. Because of this, D issued a promissory note payable to C or bearer. Okay, so, may very important factor dito which is yung bearer. Okay? Although wala pa kayong negotiable instrument, I believe wala pa kayong negotiable instrument. Pag sinabi kasing bearer dito sa negotiable instrument, yung mga bearer instrument natin, hindi na po kailangan ng negotiation, Hindi na po kailangan ng, what do you call this? Medyo nakalimutan ko. Ano yung term doon? Okay, so, hindi na po kailangan ng endorsement. Okay, hindi na po na kailangan ng endorsement ng bearer instrument. Kailangan lang po is delivery. So, once na na-deliver, or napunta, or na-bear ng isang person yung specific instrument na yun, parang as if it's prima facie, meron siyang kinalaman dun sa debt or na-acquire niya yung credit, parang gano'n, okay? So, in this case, dahil bearer siya, medyo hindi siya masyadong secured, hindi na kasi kailangan ng endorsement, delivery lang, okay na, okay? So, in this case, one day, C lost the note. Nawala niya yung note. It was found by X, so, naging tuloy, prima facie, na-deliver kay X. Prima facie na-negotiate kay X. So, in that case, on due date, si X, anong ginawa niya? Naningil siya dun sa promissory note from D. Okay? So, si D, syempre, babayaran niya kasi nakita niya yung promissory note na may pirma siya na kay X. Okay? So, yung ginawa niyang payment, valid ba or hindi? The answer is valid. Okay? Kasi nandito, Article 1242. Payment made in good faith. Hindi niya naman kasi alam kung anong talaga yung nangyari. Pero, yun nga, basta bearer kasi insecure eh. Basta kung sa kanino napunta, it's prima facie, ganun, na parang kumbaga valid or validly na-acquire niya, parang ganun, okay? So, in good faith, to any person in possession of the credit shall release the debtor. So, in that case, his obligation is extinguished kasi valid na yung ginawa niyang payment, okay? So, that is Article 1242. Next, Article 1245. So, this is dasyon. We will tackle this in detail pagdating ng next video. Kasi special mode of payment. Okay? So, next, Article 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor with regard to judicial costs. Okay? The rules of court shall govern. So, ayan. Extrajudicial costs, ang general rule, ang magbe-bear ay si debtor. Okay? Pero, syempre, depende sa, may pwedeng magkaroon ng stipulation na si creditor. Okay? Pero, yun nga, kapag walang nabanggit, si debtor ang magbe-bear ng extrajudicial expenses. Ano ang extrajudicial expenses? Huwag na natin pag-usapan dito, hindi na yung masyadong Okay? So, ayan. Last article. Okay, in case of an extraordinary inflation or deflation of the currency stipulated should supervene, the debtor or the value of the currency at the time of the establishment of the debtor shall be the basis of payment unless there is an agreement to the contrary. Okay,